So Morgan, it looks like we have a Shane Tonica wants to meet with us to discuss a family case and a problem they're having with a former mediator in a divorce.
Okay, you want to go get them now?
Let's get them.
Okay. Were you able to find a place okay? I was. That's good to hear. We're so happy to have you meet with us today.
Yeah. It turned into, I think, a somewhat beautiful day.
Yes.
A little bit.
It was nice. Nice drive-in.
That's good.
Hello, my name is Devlin, and this is my co-counsel, Morgan.
Hi there.
Thank you so much for being here today. We know you made an appointment to discuss something specifically with us today.
Yes.
Before we get to that, we like to just get to know you a little bit better, so you could just tell us a little bit about yourself.
Perfect. So my name is Shane, and so I am a 40-year-old divorced mother, and I work part-time at a retail store, and I'm just really coming here to hear about my options and see what we can do with my current situation.
Nice.
Great.
It's great to meet you.
Me too.
Are you okay with us calling you going by Shane?
Yes.
Okay, perfect. So Shane, I'm just going to quickly outline how this initial meeting will progress. We'll first discuss the rules outgoing this consultation, as well as clarifying our expectations and our role here. You'll tell us your story about what brings you here today. We'll discuss some possible legal and non-legal solutions, but anything we suggest is completely your choice. Anything we go through with or we abandon, all options your choice. We'll then discuss some potential next steps. At the end of this consultation, we may provide you with a representation agreement, which we will have you sign if you choose for us to represent you. We've also provided you with a pen and paper, so feel free to take notes. Please interrupt us also at any time. If you need any clarification, any questions, please feel free to do so. Do you have any questions?
Not at present.
Okay.
Great. And at our firm, we just always feel it's best to discuss the procedural side of fees and confidentiality in the beginning of the interview, just so you have a clear understanding of what you can expect from us and what we will expect from you as well.
Okay.
So dealing with the fees, so this initial interview with Devlin and myself will be billed at a flat rate of $100 total.
Okay.
If we all decide that we are going to continue representation for you, then you will be billed at a $200 per hour of either lawyer's time.
Okay.
You may be required to pay a retainer prior to commencing any further legal services, but that will be more determined later on once we understand the facts of your case and exactly what the procedure will be taken on for this your solution.
Is that typical to have to pay a retainer up front?
So it depends. It really comes down to what your case is. So, for example, if we find that the best solution for you is to go to trial, then a retainer would likely be paid up front to have those fees in hand so that we can further start the research and preparing the witnesses and everything in order to go to trial. Whereas, let's say we decide that, okay, mediation or quick negotiation may be a better solution, then a retainer may not be necessary because we won't need that money in the beginning to start working for you on that.
Depends too on just how many hours we're expecting the work
Right.
that you may need.
Okay.
And we can talk through that at the end of this, as well as how many hours, 15, 20, and discuss
Definitely.
what that price would look like in a retainer. Does that make
Right.
sense?
Yes.
Yes, because we try to be as open, honest, and consistent with you about what the fees will be, and we will also give you a fee agreement for you to sign at the end if we decide to have us represent you. And along with that, you also get a fee schedule that will have a written explanation of exactly what those fees are, and like Devlin mentioned, possibility of hours, etc. Then we also just wanted to quickly talk to you about confidentiality. So we want you to know that you can trust us, because trust is the hallmark of any attorney-client relationship, and we want you to feel as comfortable as possible to talk to us openly and honestly and share your story with us. So any information that you share with us today will remain confidential. We will not share this information unless we have your consent. Now, there is some disclosure will be impliedly authorized when it comes in order for us to represent you, such as if we were to go to trial or so. But outside of that, without your consent, we would not share this information. However, there are rare and necessary circumstances, whereas if we see that someone's life may be in danger due to our failure to disclose that information, then it would be on our part to share this information to the proper authorities. But anything you share with our secretaries, with our paralegals, Devlin or myself, will be protected.
Okay.
And I also like to warn That means any information that you choose to share with third parties outside of our firm, so with family members or friends, it doesn't have that same level of protection. So you want to make very careful decisions on who you decide to share that information with. And at the end, if you decide that you don't want to continue further with us, all of the notes that we take, if you're comfortable with us taking notes, and any conversations that we have today will remain confidential.
Okay.
Do you have any questions?
That was my
about
question.
Okay.
If I decided to not go with you guys, if that would still remain confidential.
Yes,
Absolutely.
definitely.
Okay. Yeah, and we've already run a conflicts check with some of the names I think you provided to our secretary, but if any names come up today, we'll probably ask you to just spell them for us so we can just get clarification in case we need to run any more conflicts checks.
Okay.
And then, like I said, we'll have you tell your story. We'll ask some clarifying questions probably throughout. And then at the end, we'll discuss some legal and non-legal solutions. And like I said before, all options are your choice.
Okay.
Do you have any questions about our role?
No.
Okay. And our secretary mentioned that this case was dealing with a problem you were having with the former mediator. So we went ahead and did just some preliminary research on the case. So if you see us look at any notes or any further paperwork that we have here, it's just to help with our analysis.
Okay.
And then we just want to make sure you're comfortable with us taking notes here today during
Yes.
this.
Okay, great.
And also you have paper just in case.
Yes, we're all prepared.
Yes.
So tell us what brings you here today.
So it's not solely an issue with a former mediator. I think it's branching more off of I'm currently divorced. About 4 years ago, I divorced from my former spouse, Alex, and we have 2 children. And currently, there are some issues going on with child custody in that whole situation. And so it's just being able to figure out where we go from that, because we did mediate our divorce 4 years ago, and we had and the person who mediated that divorce is now still a factor here with us trying to figure out this child custody modification.
Okay.
So they're helping you with now just the child custody since the divorce is done with?
So they are not. So I guess, so Alex, my ex, he had an attorney that worked with the mediation of our divorce 4 years ago. And the mediator who did our divorce, which was very amicable, more or less, that mediator has now joined the firm that Alex is being represented by.
Okay, and do you currently have an attorney as well?
I do not.
Okay.
And you did not have one during the mediation?
Oh, during the mediation, I did have an attorney.
You did then?
Are you still in contact with that attorney?
I'm not.
Okay. Was it just not needing the attorney anymore, or did anything happen between you and the attorney?
Nothing happened. I felt that almost during our mediation, it was so amicable that I really felt like we almost didn't need attorneys, and we were just paying for an attorney, and we didn't really need it.
Yeah.
And so I would have hoped that this would have gone the same way around, and I didn't expect Alex to show up with an attorney,
Right.
and he did.
Okay. During the first mediation. Okay.
So no, during, so we are having issues with our son, Luke, and I went ahead and filed a motion for child custody modification with the court, and Alex showed up with an attorney at that.
And you
hearing.
didn't have one
Yes.
at that point. Okay.
And your ex-husband didn't mention the possibility of him bringing an attorney
No,
into
he
the
didn't.
equation?
Okay. So have there been any agreements that you've signed regarding child custody so far?
We worked it out together, so the only mediating things that happened were for property and financial support, and we worked out our own child custody, which is almost 50-50 4 years ago.
Okay.
And has that been working out well for you outside of this issue you're now having with your son Luke? Can you, I guess, express more why you are trying to change the custody modifications?
Yes. So Luke is 14 years old. So we have 2 children, Luke and Molly. Molly is 10. Luke has expressed to me over the past couple of months really not getting along with his dad. They are increasingly hostile and arguing about homework. And I've really seen that his grades are plummeting, and they're plummeting really fast. And it's something that is really concerning to me as a freshman in high school. Like, those grades really start to matter. And so that's something that's really making me uncomfortable, and I want to fix it.
Can you tell us a little bit about what happened during that child custody mediation where your ex-husband showed up with an attorney?
So during the modification hearing,
Right.
So just during the hearing, we just discussed sharing facts about Luke's grades and setting a date for another hearing.
Okay, and
That's all that happened.
when was that?
And that was 3 weeks ago.
3 weeks ago. And when is your next hearing?
It is, I think, 2 weeks from today.
2 weeks from
Okay.
today.
And did you and your ex-husband, Alex, were you able to, I guess, before the hearing, talk about where he his stance on was with Luke coming to stay with you more often or changing the custody modifications? Is he open to it? No, not at all.
So he quite vocally refused changing the current situation of our child custody, which is 50-50. I mean, I went to him just trying to say maybe just during school, during the times where he's in school, if he could spend more time with me. He is just not having it. He thinks it's wrong to split the kids up.
So Molly hasn't expressed anything?
No, Molly's quite fine with
Okay.
what's currently going on.
So
And
your,
I'm sorry, go ahead.
So your ideal plan would maybe be that Luke is with you and Molly would be with your ex-husband, or?
So that Molly would continue doing the 50-50,
okay.
and that Luke would be with me
Full
during,
time.
yes, the school year.
So just during the school year?
Just during when school's in session is really what I want. So that
Okay.
way the homework problem is solved. We really have no
Right.
issues when it comes to homework. And so just being able to have that settled and that he can continue to spend time with his father on weekends or other
Right.
situations.
Right, of course.
Is there anything else that you can think of or that you'd like to share?
And so that is just dealing with the current family issue. And then there's also the issue with the former mediator. And so that I'm just really, really confused currently. Like I was very thrown off guard, and I really don't know if certain things are allowed that I saw at that last hearing.
Okay.
Can you share a little bit more about what you saw that has you kind of concerned?
Yes. So Phil Tepper was the counsel that Alex brought with him to that modification hearing. But since then, I've learned that Deborah, who was our former mediator for our divorce 4 years ago, is currently working at the firm with Phil.
Okay.
And I saw Phil, Deborah, and my ex-husband all together at the courthouse discussing what I think maybe our case. And so I just feel like there should be a rule against that or something. I don't know. And I just, I expressed it to my husband or my ex-husband, and he said that she could very well be the person representing him in court if going forward. And I don't know where the line is with that and what
Right.
that is. I'm just really, really confused.
Right. Can you tell us a little bit about how you felt maybe when you saw Phil and Deborah and your ex-husband together? Was it when you went into the mediation, did you feel like you should have had an attorney present? Were the attorneys kind of taking control of the mediation, or
Is the hearing?
during the hearing? My apologies.
I mean, the hearing was just very general. I saw them talking like outside of the courtroom after the
Right.
hearing.
Okay.
And so I felt like the hearing, seeing him come in with counsel, I felt like maybe I guess I need to have counsel now.
Right.
And that maybe that's something I need to do. But I really felt more uncomfortable after the hearing when I saw them together.
Right. Okay.
Well, thank you so much for coming in. I just want to quickly try to do a quick summary of everything you shared with us. And if you can, just let me know if anything's incorrect, if anything else comes to mind, or if there's anything else you want to add to what I'm saying here. So 4 years ago, you and your husband went through mediation with Deborah over your divorce. And during that mediation, that covered mostly property and other assets, while you and your husband decided on your own how to handle the custody.
Yes.
And your husband, Alex, and you decided that custody was going to be split 50-50 for your son and your daughter, Luke and Molly.
Yeah.
So they didn't have really issues at the time, but now that Luke is 14, he started having these problems at school, and you see an effect on grades. So now you wanted to talk to your husband about possibly modifying the child custody in order for him to be with you during the school year.
I attempted to, so I tried to talk
Right.
to him and tried to do it without getting the courts involved.
Okay.
And after that refusal,
So after his refusal, that's when the court became involved, and you
or
decided
that's when
to
I
go.
decided to, I
Make
guess
the
I'm going to
hearing.
have to go. Yep.
Okay. And once you arrived at the hearing, your husband came in with counsel, who was Phil Tipper, and Phil and Deborah are now currently working at the same firm together. And you saw that Phil and Deborah and your husband or ex-husband Alex were all working or talking together outside of the courthouse after the hearing as well. So you're really trying to focus on both the two separate issues. One, exactly what your options are available for working to change the child custody modifications, and then two, what are the lines that Deborah has and the barriers if she's crossed any lines by working with Phil and talking with Phil and your husband.
Yes, and I mean, or if she's, from what Alex relayed to me, that she can actually be the lawyer on the other side for him, that she may be the one representing him moving forward, and
Right.
is that allowed?
Right, so Phil was at the hearing.
Yes.
Was Deborah in the room?
No.
No,
But
she was
they're
outside.
the only two at that firm that do
Okay.
family.
Okay.
Is there anything else that you can think of that we should know?
I don't think, not right now.
Okay.
Okay. Well, thank you so much for sharing your story with us. Morgan kind of touched on this, the concerns that you've been having. I'd like to know specifically what your main priorities are in coming in today.
So my main priority is that hearing is 2 weeks from today. Just being able to kind of see what my options are and what to do moving forward to get that child modification granted, so I can be able to have Luke during that so we can fix his grades. And then also hopefully being able to figure out how Deborah cannot be the counsel on the other side.
Thank you so much for sharing your story with us. We definitely understand how this has put you in a very difficult situation because you're just trying to do what's best for your son, but everyone knows divorce custody can always be a very difficult place to try to deal with. So we want to do everything we can to help you, but we just also want you to know that at the end of the day, it's your decision how you want to move forward. We're going to give you as many legal and non-legal options that we think would best fit your case and what we think would best help you, and we'll be here to guide you and advise you in any way that you need. But we also are here to respect your decision and make sure that you're comfortable with any decision or steps we take.
Okay. One other question I've had just listening to Morgan's summary, did you discuss confidentiality at all with the mediator during that first mediation?
I think there was like a general confidentiality thing that we signed,
Okay.
but I can't remember off the top of my head, but I think that there was an agreement that we signed for confidentiality.
And do you know if there's anything with conflicts? Do you remember that word coming up at all during the mediation?
I don't.
Okay.
Do you have a copy of that agreement that we could see?
I'm sure I do at home in my files.
Okay, great. Yeah, if we could see a copy of that. So hearing your first two priorities, the hearing is in 2 weeks from today, and you want to make sure that you have possibly representation to be able to get your son Luke to help him with his homework. And then the other priority you named is that you do not want, or you would hope that Deborah cannot be counsel and is not helping your ex-husband's counsel with his case. And so kind of going off that, I think the first thing we could talk about is obviously your first priority is the hearing is 2 weeks from today. So you'll be entering into a place where you feel like you do not have necessarily the power, correct? And maybe you're interested in hiring possibly an attorney.
Yes. I mean, I'd hoped we could just mediate this as we did before. I mean, why waste all the money going to trial and doing all of this stuff in the courts when I felt like it worked so well last time? Why can't we just do it again this time? And then I showed up and things were different.
Right. So it sounds like what you're saying is that your outcome maybe would be to be doing another mediation instead of kind of proceeding with this hearing.
I would like that if
Okay.
we could get Alex to agree to that, or maybe see that as an option.
Yeah.
I just feel like that's the more like financially like more financial, economical situation.
Right.
Okay.
Yeah, we definitely understand that. And we think that would be, so we would want to make that a priority, try to get that as quickly as possible, see if we can talk, if you would like us to reach out to his attorney or their firm and see if that is a possibility to open up that discussion. And then if that discussion is not available, if he's completely refusing to have that, then start preparing for what that trial would be like for the custody.
It is possible, if you're in a hearing, to go back to a mediation, and I think that would be something that I think from what you're telling us today maybe sounds like would be in some best interest. I think there may be some things that you need to discuss. In a hearing, you would still be able to get your voice out, but in a mediation, with having a neutral third party there, like you've done it before, it can be very helpful to kind of get all the solutions out, all your options on the table, a mediator there to facilitate discussion. And that could be, I think, in your case, and I think you can see it too. That would be really helpful. Something we can do just right off the bat is we have a couple family law attorneys we could refer you to, who would maybe be able to you could discuss your case with them to see if it's possible to move this mediation, move this hearing back to a mediation. Would you be interested in maybe receiving some of those referrals?
So are y'all not family attorneys?
No, so our role is more looking at the professional responsibility and the ethics of other lawyers and how they act in representing or mediating for you. So while we may not be able to help as much with the custody side, we can definitely help you with whether or not Deborah can represent Alex. And so,
So do you think that should be handled first before the custody
Oh,
situation?
yes.
Right.
Yeah.
I just wanted
Because
to
that is 2 weeks from today.
Definitely.
And so I just...
Absolutely. I just wanted to make sure, especially because it is, you mentioned, as your first priority. I think that knowing that we can get you referrals right away would kind of maybe take that off your plate for right now, to know that if you could go back to mediation and have possibly an attorney even to discuss your case with, even if you don't end up hiring them or you don't end up bringing them to your mediation. I think just hearing from what you've been telling us, maybe with the issues that are going on, it could be helpful to have that in the back pocket. Do you think
I think
that would
that's
be the
nice
case?
to know as an option, but I'd rather really hear about, I guess, Deborah and moving that forward before these 2 weeks, before that hearing.
Definitely.
Or we could, I know some of my friends who've had family law issues with their own ex-spouses said that you could move hearings back or something.
Yeah.
Maybe just getting this taken care of, because I don't want to go into mediation and Deborah be there.
Oh yeah, no.
So
We don't like that either.
Yeah, right. And she also, we can talk more about that second priority right now.
Yeah.
Deborah should not be in that mediation with you.
Okay.
When you went into that first mediation, you signed most likely, and that would be something I think we would need to see, as a confidentiality agreement. You probably signed something at the beginning or at the end when your mediator discussed confidentiality. And as a mediator, she's bound by those mediation association rules. If you're familiar, mediators are basically like how lawyers are under like a state bar. Mediators are under something similar, where they're under kind of an association. There are rules guiding how mediators are able to conduct their mediations. And one of those rules is not necessarily being able to represent parties as a mediator and then moving into a firm position representing someone who was their previous client. It would be something like a conflict of interest.
Even if child custody, I guess that was the thing when I was talking with Alex. He said it's totally fine because she didn't do the child custody portion. And so...
Well, see, so the issue there, even though she didn't do the child custody portion, she still worked with you and Alex on mediating your divorce. And so the conflict of interest would be that it was still you were her client under the mediation. She was still working as a neutral party that was helping both of you all find mutual benefits here. So she wasn't representing Alex.
Correct.
It'd be different if she was Alex's counsel during your mediation and then wanted to be Alex's counsel during the custody battle. But here she's supposed to be a third party that's creating trust for the both of you and helping the both of you get the greater benefit here.
Okay.
So by doing that, now that she's gone to a new firm, she cannot have that access to helping Alex with the file, because that would be adverse to you.
Okay.
And so there's it's almost as if when she went to that firm, they would have to put like a cone of silence around her. and she can no longer have any say in what's going on with Alex, and she shouldn't have any information about what's going on with Alex as well. Right. And so that can lead to, as Devlin mentioned, how lawyers are governed by that state bar and how mediators are governed by the Mediation Association. Two options available for you to file complaints against Deborah, to make that aware.
Mm-hmm. Especially if Deborah may have gone to that firm and shared anything
Right.
with Phil. That is a breach of that confidentiality that she made with you. Mm-hmm. At that point, she probably said something like, I will take notes, but I'll destroy all my notes. Anything you say here will not be allowed in a hearing, or except in like very specific circumstances, cases of abuse or something like that. So
Okay.
Unless like that would be a case where maybe she'd be able to kind of break that confidentiality, but she is sworn to that. So if she is helping at all with this child custody issue
Mm-hmm.
and saying anything that she learned in confidence during that mediation is most likely improper. Does that make sense?
Yes. I mean, I guess I'm just confused that, I mean, when Alex went to her and asked her about it, she said it was fine. So, I mean, shouldn't she be aware of these rules?
You would think so.
I'm just a
it's
little
one of those
confused
things.
here.
Yeah.
Okay.
And it's a little difficult. I know lines get blurred easily when that transition occurs from going from a place as a mediator to now working at a firm, and exactly understanding where she's able to do what her duty is to her former clients and now as Alex's prospective client. And typically what is done when an attorney goes into a new firm is they would run a conflicts check. She would have to mention names of people that she's worked with in the past, any clients that she's had. So even as a mediator, she would have to mention that she was the mediator for these two parties and that she had these confidentiality agreements.
Okay.
And then from there, the firm would say, okay, Alex, we've seen that name before. We have that on here too. We need to separate the two. She cannot have any influence on any cases dealing with Alex. So
Okay.
you were definitely right to notice that red flag and realize this isn't okay. Something's not fair
Right.
here for you.
Your instincts were right.
Yeah.
So I guess where do we go from here and
Yeah.
dealing with that if she's already been a part of this
Yeah.
discussion?
And it would be, so she wasn't at the hearing in the room. That would be something we would need to look into to see if she did have any discussion with Phil or with Alex at their firm or in a meeting another place. It just doesn't seem from what you're able to give us right now if that's the case. And it's possible.
Mhm.
And I think it could be, especially when you said there's only 2 attorneys that do family law at this firm,
Yes.
I think it's more likely
Right.
that they may have talked. But we do benefit of the doubt. Maybe we said that she maybe knows her conflicts, and maybe she hasn't discussed this at all. But when you did ask Alex about it, he said, "Oh, it's fine." That may be a red flag too, that he knows that she's been helping him.
Right.
So I
Okay.
think that would be the first question to look into this a little
Yeah.
bit more and talk to, I think, Deborah and Alex and Phil and figure out if that's the case.
Okay.
And it's also not even if it's more of even the appearance that she could have been helping, or the appearance by you seeing them all 3 together and leaving that, because the court of course wants you to feel comfortable with whoever your mediator is, whoever your counsel is, and feel like you can trust them. And just having them outside of the courthouse discussing who knows what, and
Right.
especially in a small firm in a town like that, that can lead to the appearance of some type of breach of confidentiality or conflict of interest, and that alone can be enough for a complaint to be filed against her.
Exactly.
So I guess with a complaint, where does that put us in a timeline? I mean,
Timeline-wise.
Luke's grades, I mean, that's
Right.
really stressing me out. And so
Yeah.
is it going to are we going to prolong this issue, or
Right. Well, I
what's
think
gonna
we
happen?
would do something quickly. I think if you choose for us to represent you, I think we would first want to sit down with either having you and Alex in the room, or we speak specifically with Phil and Deborah and discuss if this is happening,
Right.
what their conflicts are like at this firm, to know if they have discussed anything, and kind of negotiate that.
And the likely need of her to recuse herself as well. We can
Absolutely.
bring that up as well to try to hurry along, because we understand that 2 weeks till the trial, so the best to get her out of the picture as soon as possible, and possibly even have the Phil recuse himself too,
Right.
depending on if he knew about the conflict of interest as well, and which would cause Alex to have to seek representation outside of their firm.
Right.
Okay.
And perhaps Alex would want to then mediate with you, just one-on-one. You never know. So I think that would be first step,
Yes.
is sitting down to negotiate that. Does that sound like something you'd be interested in?
Absolutely.
Okay. I think we'd want to do that ASAP. So something we can do right after this is kind of look through that and just make sure that we're bringing up all the right things, all the right conflicts that could be coming up, and do a little research, and then bring that up, and we can set up a date maybe next week to call them and discuss this specifically, or in person, and just talk through this, especially if you have a date in 2 weeks. We say this needs to happen, and if they're saying no, nothing's happening, it's all fine, and we don't feel like that's true, that would be something that we could raise, or you would raise in some sort of like state bar complaint.
So I can't raise at the hearing?
It could be raised at the hearing, if you're there and you're finding that he's still there and you're feeling uncomfortable and you think there's this power imbalance, you feel like she represent us in a mediation. I think a judge would see a red flag there, like we're seeing a red flag, right? But I think there are questions, right? It wouldn't just be automatic that that she had this conflict. That maybe she is in a cone of silence. Doesn't sound like it, but maybe. So that could be a possibility to file that kind of complaint.
Okay.
Right, and that would be something we could look forward and talk through if it came to that.
Okay.
Do you have any questions so far?
I guess just being able to have more of a clear outline of our timeline.
Yeah, of course.
Just being able for those 2 weeks, or like for these 2 weeks leading up to this particular hearing.
Definitely. So,
and if there's anything that we can do, I mean, it's the middle of the school year, and so that's just also stressing me out, and just being able to kind of get in my mind like what that timeline's looking like moving forward, and if there's this potential state bar complaint, like where does that put us in me being able to get Luke during the school year, and those things, or can they go on at the same time type situation, or what we're doing there.
Right. So I think first things first, I think what we would do after this meeting, immediately after, is we would draft up, just thinking logistically, we would draft up a memo for you. We would make sure you have all the information we talked about today, as well as kind of that legal analysis we talked about, talking about mediators and conflicts and confidentiality, just making sure you have that in writing so you're aware of exactly what we would be discussing with the other side. Get that to you immediately today. Next steps, we would also provide you with a representation agreement. If you choose for us to represent you, we would need you to sign that and to send us back. If you sign and send that back, then we can start working a little bit more on this, rechecking some of those conflicts. But going forward, I think calling right away, I would say even as soon as we get that representation agreement back, calling them immediately to discuss it. And I think if we could get contact information, so that would be one thing we would want to get from you personally, Shane. So with that, we can, and like we mentioned before, we need to call them right away and have them and tell them about the fact that she was the mediator in your divorce, just to make sure that was aware, because we don't know if Deborah herself made that aware to her firm when she started working there, and trying to leverage that a little to see, you all don't need to be representing him in this hearing. Maybe that'll lead Alex to want to negotiate or mediate outside of the trial. If not, it won't affect you. He would still need to get counsel for the trial to continue there, for the hearing to continue. Right, and I think that's why we also mentioned at the beginning possibly getting a family lawyer. There are possibilities in a hearing, either continuance, so that would just be extending that date. I think that would be something we would want to do. It sounds like it's in 2 weeks, and if we do think there's this conflict, we would, I think, either a family lawyer if it does continue on a trial, or mediation. I think it might be in your best interest to push it back, hopefully not long. I know you want to get Luke. So hopefully that can happen shortly after. And I think what we also can do is we have a referral for a few just counselors outside of the legal aspect, that if you'd like to use them to talk to Luke. I know sometimes going through the divorce and going through all the court systems with parents going through that can have an impact on their child sometimes. And it seems like you are concerned that it's not just the school, but his environment at home with his dad. And of course, we know teenagers, as they grow, they go through that rebellious stage as well. So sometimes it's just nice to have that outside guidance coming in, outside of the legal atmosphere, that can just talk with you, talk to your son, possibly talk to Alex as well, and really just help everyone get on the same page. Because at the end of the day, we want to make sure that Luke is taken care of and that Luke doesn't feel any negative pressure or anything like that while we just figure out the best way to go about this trial.
Okay.
Do you have any questions so far?
No, I think that's a good idea. And just being able to do that in the interim. So I think being able to get those the counselors referrals.
Definitely.
I think
Okay,
if
great.
we decide to move forward, I think that would be really important.
Okay, so what I'm going to do is I'm going to provide you with our card, and I'm going to write a couple things on the back.
Okay.
So we're going to put down that we're going to send you immediately after this meeting, or we'll make sure our secretary provides you a copy on your way out, and it'll be the representation agreement, as well as a copy of our fee schedule. So that just outlines all of the fees going forward, like Morgan said at the beginning, just in a little more detail.
Right.
So make sure you have that.
And then we'll also make sure that we get the referral for the different counselors, just so you can have a decision of who you want to work best with. And also mention on there that we would need the contact information from Deborah and the firm
Yes.
from you.
Okay.
Yep, so we'll get contact information from them.
And a copy of the agreement that you all made, of the confidentiality agreement
Yes. Okay.
from your first mediation as well.
And we'll provide you with those referrals for counselors and the family lawyers. We'll add that to our memo, which we'll be sending by this evening.
Okay.
Okay, great. And so once we get that contact information, the representation agreement, we'll let you know as soon as we're going to set up that call.
Okay.
And if you want to, sit on the phone call, or if we end up doing an in-person meeting, we'll let you know when that is. We'll try and make it in the next week.
Okay.
And then setting up that meeting with the family law attorney, I think would be helpful in extending that to a continuance. We can look into that a little bit, just to make that quick for you. But we do think a family lawyer with that expertise would be helpful.
And now with this, I know in the beginning you talked about a retainer. Do you see this as being potentially something where I would have to go ahead and put down a retainer type situation, or
So
off the
again,
bat?
it would really depend on if we do have to go to trial or not. I think what we're really going to aim to do is try to get this back into a mediation.
Okay.
Really try to get into just a neutral party to
That's
talk
really
with you
what
all.
I'm wanting here.
Possibly a counselor to come in as well, so that we can just handle everything, make sure that Alex is taken care of, make sure that Luke is taken care of, make sure that
Molly.
Miracle is taken care of, and then Molly's taken
Yeah.
care of. And so with the mediation retainer, would it be necessary? And if not, if we do have to go to trial, then we would talk about
Okay.
the resources
Yeah.
for that.
And a lot of this outlined in the representation agreement. So
Okay.
give that a good look over and review it, and just let us know if you have any questions as well.
Okay.
Like I said, we'll set up that with our attorney.
Right.
With our attorney, we'll set that up with our secretary to send that out and get that to you.
Do you have any other questions?
I don't, not at the moment.
Okay, here's our card.
Thank you.
Thank you so much for coming in.
It's lovely to meet you.
Of course, if you have any other questions or thoughts, give us a call at any time. So we definitely want to get on this as quickly as
Yes.
possible.
Okay, so first thing is that memo.
Okay.
So let's get that to her immediately.
I'll get on that.
Perfect. And just like the summary of your notes, I think will be great.
Okay.
And then I will start doing some of that, a little bit of like research on what we're going to deal with exactly when we sit down with that council.
Right.
Hopefully next week. Let's look at
Yeah,
our
we need to
schedules.
get that done as quickly as possible,
I
and
agree.
just really get them to understand that Deborah cannot represent him at this point. And even them being in a small firm may need the whole reason for him to get a new representation altogether.
Yeah.
And possibly, if we can really just kind of explain to Alex why mediation would be the best way to handle it at this point, I think that would be a good starting point.
Yeah, I wonder if we should have a family lawyer in the room. We can discuss that perhaps with Shane going forward. I think that would be good. I do think it does sound like there might be a conflict here, just from what she's saying. I think we need to confirm, but I think my gut is telling me that. So let's look into that a little bit more.
Okay.
Okay, and then we need to send her referrals for family lawyers and for counselors. So let me look into that as well. I think that was a really great suggestion for a
Yeah.
counselor.
Okay, I think that's all we need from here then.
Okay, great. Thank you.
So, Katie, who do we have coming in today?
We have an appointment with Shane Tanaka. They want to meet with us to discuss a family case that she's having, and she's having a problem with her former mediator in her divorce.
Well, immediately when you mention mediator, I'm thinking about our rules as attorneys that govern our professional conduct and discipline, and the mediator rules. So I guess we're just going to have to get Shane Tanaka and figure out what was going on here and see if either of those rules have been violated.
Yeah, I'll go get her.
This is my partner.
Tatiana, nice to meet you, Ms. Tanaka. Are you comfortable if we call you Shane?
Yes, that's what I just told you.
Did you find our office okay?
I did.
Traffic wasn't too bad for you?
No, it wasn't too bad.
Thankfully, the sun has come out a little bit as opposed to the rain this morning.
I know.
All right, we'll go ahead and get started. As I said, my name is Katie. This is Tatiana. Please feel free to call us by our first name during this meeting. We do have you here for an initial consultation, so we have about a little over half an hour together here today just to give you a timeline. Thank you for paying the $100 consultation fee. That does cover our time here together today, and at a more appropriate time in our meeting, we'll discuss our fees in more detail.
Okay.
Now, Shane, are you an attorney by chance?
No, I'm not.
Okay, so we want to shift a bit and talk about what we call the duty of confidentiality. I don't know if you've seen it on Law & Order or heard some people say it, but basically it's a rule that governs attorneys. And it really imposes upon us and impresses upon us the importance of maintaining your confidentiality. Okay. You can feel comfortable at this firm knowing that Katie and I take that duty of confidentiality very seriously. So please feel comfortable today sharing with us whatever you think you need to so that we can give you the proper advice.
Okay. Thank you.
And Shane, Tatiana and myself will be taking notes during this meeting. That's just to ensure that we get all the accurate information down that you tell us. There's pen and paper provided for you as well. Please feel free to take down any notes from today's meeting. And at any time, Shane, if we're explaining something, maybe using too many legal words, or you need us to slow down, please don't hesitate to stop us. We want to make sure you're completely comfortable with all the information we tell you before you leave here today.
I appreciate that.
And I know this is a lot of information, but we just want to give you a roadmap of what to expect in today's meeting. So in just a moment, Tatiana and myself will ask you to explain what brought you to our office today. We'll then follow up with some questions just to make sure we're understanding your situation, and then we'll provide you with the legal advice pertaining to your situation and the different options that you have to achieve your goals that you came here today. Now, those options will range from the legal to non-legal, the most aggressive to the most conservative. We just want you to be aware of all of your different options today, but at the end of the day, it is your decision. We want you to feel comfortable with whatever decision is made here today. Tatiana and myself will never do anything that you don't consent to or you don't want us to do. We're here to help you with whatever decision you do make.
And with that in mind, Shane, today while we're speaking, there may be some exceptions that arise that concern anything that you divulge to us. Katie and I will immediately address those with you so that way you can have all the information and feel comfortable about this meeting. Okay. But we've talked for quite a bit, so we want to hear from you. If you could tell us, what are your goals from this meeting?
Well, I guess my first thing was, I know you said you'd discuss fees later, but just going forward, I'd like to know what those fees particularly are.
Yeah, absolutely. So our fee is $200 per hour. Tatiana and myself do work together, but we would never charge you for something that we are working together on. But that's something that once we decide whether you need our representation or the best course of action for your problem, we can discuss that further at that time.
Okay, great. Thank you.
Do you mind if I ask Shane, why were fees a bit of a concern for you? Is there some money issues going on at all?
Well, I mean, I work part-time at retail, and so, I mean, I'm always obviously just trying to look at the most economical way to move forward with our situation.
Just wanted to make sure, okay.
Yes.
Aside from the fees that Katie and you just discussed, what are the main goals, I guess I should say, of their situation and what you would like to happen after this meeting?
I mean, I guess just being able to know my particular options for the situation that is currently here and how to move forward in the most timely way possible.
Okay. And just to make sure that we have your goals in mind, first you want to know your particular options that you have, and second you want to know how much time you have to facilitate those options, because it seems that time is of the essence.
Yes.
Perfect. All right, well, if you could start from the very beginning, Shane, and just let us know what happened. Why are you here?
So what happened, I have 2 children, and so Alex is my ex-husband, and we divorced about 4 years ago.
Okay.
And my children are Luke and Molly. They're 10 and 14, and Luke's 14. And there's just been some issues as far as Luke's grades currently. and Luke kind of letting me know some issues with him staying with his dad. And so those have kind of pressed upon me and stressed me out a little bit to the point where Luke has expressed to me he'd rather stay with me.
Okay.
And what has he expressed to you?
Just that he is constantly fighting with his dad about homework and situations, and I've seen personally his grades have been plummeting, and so that's been stressing me out as a 14-year-old. It's high school; those are when those grades start to count, and
Right.
so I just want to get that fixed as soon as possible, and for him to be happy wherever he is at.
And when did Luke come to you, informing you of all these things, and when did you begin to notice his grades dropping?
A few months ago.
Okay. And now after he made you aware that he wanted to change where he was living, he wanted to come be with you, did you speak with your ex-husband at all?
I did.
How did that conversation go?
So, we divorced pretty amicably. We set up our own child custody agreement together.
Okay.
And it's pretty much 50-50. And so I went ahead and spoke with him about Luke's grades and about Luke expressing that he wanted to be with me, and I was just trying to tell him maybe just have him more with me during the school time.
Monday through Friday.
Yes,
that way.
just being able to kind of fix that.
Mm-hmm.
And Alex was not having it, was absolutely refused. And so that is just where I had hoped we could do it together and it could be just a nice conversation, but that was not met with any sort of enthusiasm.
And when did you have this conversation with Alex?
I think almost a month ago.
Okay. And you haven't had any further discussions about it?
So after he refused, I went ahead, just because of Luke's grades, and went
Right.
ahead and filed for a hearing for child modification of our current agreement.
And when you say you filed, are you represented with that case by another
No,
attorney?
I'm
So you're doing
not.
this on
So
your
I
own?
did it on my own.
Okay.
And do you remember when you filed for a child modification?
That hearing was 3 weeks ago.
Okay. And how was that hearing? How did it go? Was there any resolution at the hearing?
Well, that hearing, unfortunately, so I went in thinking that because we were both not thinking that Alex would have counsel coming into the meeting or to the hearing, and Alex came in with counsel.
You were taken aback. It was
Yes, and
shock.
I was just,
Okay.
I didn't expect that, and so I was in there represented by myself, and not too much happened at the hearing. It was just letting us know, agreeing to share information about grades, and setting a hearing date moving forward. But after the meeting is what really concerned me.
What happened after?
So we had a mediator for our divorce 4 years ago, and that was Deborah Noon. And Deborah, I found out since after she joined the firm that Alex's attorney, Phil, is with. And I saw the three of them at the courthouse all discussing after our particular hearing. And so that just really confused me as to why Deborah would be,
Right.
or if Deborah's even allowed to be kind of
Involved.
discussing.
Right.
And when you say them three, Phil, Alex, and the mediator,
And Deborah,
we're
yes.
discussing. Okay.
Do you remember when you were in your mediation, did you share any information with Deborah about the mediation that you think she may have shared? Do you remember what you said to her?
So in that mediation, it was just mainly, we didn't discuss child custody or anything because Alex and I did that on our own.
Right.
But it was just more of property, like assets, and financial support
Okay.
in mediating that.
And have y'all had any further hearings since that hearing 3 weeks ago?
No.
Or nothing's happened since then?
No.
Okay.
Now, when you saw all of them together, you mentioned that you just didn't expect to see all of that.
No.
Did you have any conversation with Alex at that point?
Yes. So I actually contacted Alex because I was just a little confused.
Right.
I mean, I liked Deborah, and so I thought maybe Deborah could mediate this situation with us.
Mm-hmm.
But after seeing them together and finding out that she's a part of that firm, I became concerned. And so I called Alex, and Alex said that he discussed it with her and that she very well could be the attorney representing him.
Okay.
Just because that our mediation did concern child modification, and so she could still be able to represent him through this custody case.
And when was that conversation with Alex?
That was about a week ago.
And after that conversation, have you had any other communications with him or his attorney?
No, I haven't.
And since this has been filed, you guys still have 50-50 custody of Luke and Molly?
Currently right now,
Okay.
yes.
And I do just want to, for a second, because we're dealing with a lot, Shane, your kids are involved.
Yes.
And 100% I get that you want to be a proactive mom, so I really just want to put my pen down and put it to the side. How has Luke been doing since you guys have started this process?
I mean, his grades are continuing to plummet,
Okay.
and so that's why coming in here in the beginning, I wanted to know as timely as possible how we can address all of this situation
So we can help
currently.
Luke get back on track.
Yes.
And is Molly, you mentioned your daughter, she's 10. Has she been affected by this at all in any way? Have you noticed anything about her behavior?
No, she's fine, and she hasn't really expressed anything like Luke has expressed in like not wanting to be with a certain parent or anything like that. She's fine with things as is currently.
Okay, well, I'm glad to hear that.
Yes.
Yeah. And Shane, we know this is very difficult and want to check on your children, but how are you doing as well? I know this can be very stressful. This is your children. Are you doing okay right now?
I mean, I just want to get this solved, and I
Absolutely.
would just want to make sure that that we do it quickly, just
Absolutely.
with Luke's grades. I don't want this to end up hurting him in the long run.
Yeah,
Right.
and that's what we're here for. We want to make sure that we take that stress off you today and give you the answers that you are here for, so that we can alleviate that stress that is on you and your children.
I appreciate that.
Now, we have asked you quite a bit of questions, but before we shift gears, as Katie described during the roadmap, is there anything else you think we need to know about the situation, Miss Noon, the mediator, your ex-husband Alex, anything else?
The next hearing is 2 weeks from today.
Okay, which is why time is of the essence.
Yes.
All right. Well, you know what, Shane? Time is of the essence, and here at this firm, we're going to make sure that we give you the answers you need. So at this point, what we want to do is I want to summarize everything that you said to us in a really quick fashion, just to make sure that Katie and I have the correct understanding of what you've been dealing with so we can give you the proper advice.
Okay.
Now, you mentioned you have been divorced from your ex-husband Alex for about 4 years. You have 2 children, Luke and Molly, Luke 14, Molly 10. And throughout the divorce, it was pretty amicable. You set your own child custody agreement with him where it was basically 50-50. But your son came to you about a few months ago, and he informed you, that I actually don't want to live with Dad anymore. We're constantly fighting. I would rather live with you. And you had been noticing since a few months ago that his grades were dropping. You went to your ex-husband and tried to have a conversation. You said, hey, Luke's grades are dropping. He said he wants to come live with me. Can he just live with me at the minimum during the school week?
Mm-hmm.
Your ex-husband was not happy with that idea.
Yes.
At that point, you went and filed a child modification just so you could get Luke in your home during the school days so he could focus on his grades and get him back up. That was 3 weeks ago. At that time, you thought you and your ex-husband would be unrepresented by any attorney.
Correct.
You walked in, you saw him with his attorney, Phil.
Mm-hmm.
At that point, you were kind of confused, and then you saw your ex-husband, his attorney, Phil, and a mediator, Deborah Noon, and you recognized her as a mediator who'd handled your divorce.
Correct.
You then contacted your ex-husband again and said, hey, this doesn't make sense to me, but if Ms. Noon is involved, maybe she could help mediate this, to which he informed you that she actually may be representing him in this particular custody issue, and that didn't sit too well with you. And that was a week ago. So
Yes.
then you reached out and you're trying to figure out the options that you have, because in about 2 weeks, you have to have another hearing.
Yes.
And Luke's grades are of the utmost importance, and you want to address those as soon as possible.
Correct.
Does that all sound about correct?
Yes. I mean, my main thing is just, can Deborah represent him? Like, is that okay?
Right.
I think that just doesn't sit well with me, and I'm just real confused as to how that could potentially be allowed here.
Right.
Absolutely.
And with that in mind, I have changed your goals. We asked you at the beginning, but it seems now that that's your first goal. Can Deborah do this? Secondly, what are the options you have if she cannot to stop this? And how can you do it in the quickest way possible?
Yes.
All right. Well,
And we'll give you these options, and also we'll let you know what it's going to look like moving forward, how you go about doing what we tell you today. So keep that in mind. We'll get to that as well.
Okay.
so I want to start with answering your question straight up. Deborah cannot do that. Your instincts were absolutely correct. Now I want to tell you why, because it seems like you're a woman who likes information.
Yes.
Under the rules of professional conduct, mediators who are attorneys are subject to those rules. Those rules govern how attorneys can behave and their ethical standards. Under those rules, there is a particular rule that deals with a mediator who leaves and goes to a firm. A mediator is not allowed to represent anyone in a matter that they had connection with as a mediator, that they participated personally and substantially in. So the fact that she was the mediator.
So even if we didn't discuss child custody or anything, that still applies?
Yeah, because under the rule, it is same or substantially the same. So in that, you were the same parties. And so you're not sure what type of information she may have learned through that mediation that she could try to come out within the child custody case. And so since it is same or substantially the same, I know they're legal terms, but under our rules that we're governed by as attorneys, and Ms. Noon as a mediator, she cannot represent either one of you as parties to another case. And especially in this case, because it is dealing with your family issues, and that is what your divorce affected your family. So they can't have that. She can't represent you guys.
And the second tandem to that rule is that she cannot do so unless she gets everybody who was involved, all the parties, informed consent. And it does not seem like you did that.
No.
Right. So with that, there are two different buckets, Shane, that I really like to put those ethical rules lawyers have to follow in. One is the disciplinary bucket, and one is the civil recourse bucket. What can we do to stop what's happening over here?
Okay.
In this bucket, on the discipline side, if you want to, you can file what's called a grievance against Ms. Noon, and that grievance would basically subject her to discipline for her actions. Now, Katie and I told you at the beginning we're going to pursue legal and non-legal options. I think there's a non-legal option here that can quickly and timely get you what you want for the most part.
And with that, what she's explaining is we can send her what we call in the law a demand letter. And that's just saying, Ms. Noon, Ms. Tanaka has come meet with us. She has let us know that you are currently going to represent Alex in a child custody case, and pursuant to this rule, you're not authorized to do that. And that will just give her notice that she's not allowed to represent Alex in this case. And we can either do that on a phone call if you would prefer. We could do that either way. It would be up to you. As we said, the decision is yours today. And that same thing that we would say in the letter. But with that in the letter, we would let you read it before. And that nothing would be said that you don't want us to say. Everything, like we said, you would consent to everything that's sent from our office, so you would have the ability to read anything we say. Okay. But that's a way that before any legal options, if you don't want to go that far yet, is we can say, like I said in the letter, you're not allowed to do this. And she may just have needed a refresher and just said, you know what, they're right, I can't do this. If she doesn't respond to that letter, if she doesn't agree, that's when you can go through the process of what she said of filing the grievance against her for the actions that she's continued to do.
So now I'm still a little confused, because if they have had conversations already and we send this demand letter, as you're saying, and then they say, okay, well, Phil's just going to represent. If Phil's already had conversations with her, so can he still represent?
You have
Alex?
Very great instincts, Shane. You probably should pursue a career in the law. The second part of that rule describes imputation. And what that simply means is that if an attorney goes to a firm and they have some murky conflict issues, which is what Deborah has, a conflict of interest issue, it can be imputed onto other attorneys in the firm if the firm and Deborah New don't take steps to what's called screen her out. And what that simply means is really to put up an isolation wall to try to end that conflict of interest.
Okay.
To do that, they would have had to give you written notice, not a simple phone call or with Alex saying, yeah, Deborah might represent me. It's not that. It has to be written notice. And you have not told us anything to indicate that you've received such.
Anything.
So it can be imputed onto the entire firm once they have hired Deborah and she works there, because conflicts for lawyers carry over when we move.
Okay.
Yeah, and I can see that as a concern, and that is a very valid concern. So we can also put that in this letter that we're going to send, that not only can Deborah not represent Alex, but neither can Phil, and that we would request that both of them cease their representation with Alex pursuant to these rules that they're currently violating. And so that's step one that we can do. And then step two could be filing the grievances if they were to continue violating the rules and not withdrawing as representation for Alex.
Okay.
Now, you made it clear to us that you want this resolved as soon as possible. So while Katie gave you a step one, maybe I can give you a step half. I do think that because you had such an amicable divorce, I know that first conversation with Alex didn't work.
Yes.
Are you open to trying again?
I think at this point, with him already saying, like, not only after trying to talk to him about Deborah being on the firm, and he's saying, well, she's going to represent me, he showed up to court with representation. And so, I mean, I thought maybe we could mediate this again, even if we went to mediation. I thought that worked well the first time.
Right.
But he showed up with counsel.
Right.
And so I mean, I would be open to trying. I'm most open to mediating this situation.
Okay.
Just because that seems to be the most economical way to do this, rather than paying attorney's fees for going to trial and hearings and things. But I don't know how to get him to
that point,
to be open to that after this whole situation.
Well, just to kind of give you a timeline, just so you can understand what this would look like. If Katie and I send this letter to their firm, they're going to have an opportunity, obviously, to review it. That's going to take time. They're going to probably try to go through a process to avoid having to withdraw from representation of Alex. If they do ultimately decide to withdraw, Alex won't have an attorney. And if he wants to get one in our jurisdiction, you know, the court may give him time to do that. Okay. So my concern is the fact that you want this resolved as soon as possible.
Yes.
Now, we can't communicate with Alex because you have indicated to us he's represented by counsel.
Mm-hmm.
But if you, as his ex-wife, wanted to say, look, please, let's just try the mediation one more time. It's about our son. I think it may go a long way, especially if he no longer has an attorney. If both of his attorneys have had to say, we withdraw, it may make him amenable to talking.
So you think maybe contacting him after we send the demand letter, or trying before? What would y'all?
That's up to you and what your situation is. We don't want to make you do anything that you're not comfortable with. But with that, with the demand letter, we can say, you know, we are going to have a response within these days, within 2 days, within 3 days, or our client will be doing action against you. And so with that, that's up to you how you want to discuss with Alex. If you think that it would go somewhere, if you had this discussion before the demand letter sent, if you think the demand letter maybe will make things, you know, make him less happy and not wanting to settle with you, then you can definitely have that conversation before.
Okay.
If you think maybe sending the demand letter will say that she's serious and we need to do this, then that's something that you can think about as well. But it's really just what's best for your situation.
Okay.
That was a lot. I really do want to hear from you, Shane. Kind of what are you thinking, timeline-wise? Do you want us to send this letter today? Do you want to wait and try to talk to him?
I mean, I guess my thing here is with doing that, I mean, you know, I want to do this as fast as possible.
Right.
I think just maybe being able to take this in and just try and maybe game plan it out just to kind of see. I don't think the demand letter today necessarily, but the hearing is in 2 weeks. And so just being able to try to reach out and see maybe the likelihood of him maybe wanting to mediate, since I don't think we will be able to do this, to do another modification agreement on our own.
Okay.
Maybe.
So let's start a game plan. I'm a writer person, and I like to have a to-do list. If we write what's called an action plan for you, you always have the options, and I tell people this: you can do nothing or you can do something. You are definitely in the do something box because you want to address this as soon as possible. So the first thing is you want to have a conversation with him. One last stitch effort. And now, after you have that conversation with Alex, what we can do is, Katie and I can give you our cards. based upon that conversation, you can give us a phone call back at your earliest convenience, and we can figure out where to go from there. If he says yes, I'm amenable to the mediation, trying to figure out how we can modify child custody, then you won't necessarily need us. Quite honestly, Katie and I do not specialize in family law. If you would like to be represented, we can give you some names of people who could help you if you wanted representation at that mediation. But if not, you don't need us. Now, if you spoke with him and he decided, nope, still against it, don't want to do it, we can proceed from there.
Now, in that phone call, would I go ahead, I guess, do I let him know that like his attorneys can't be of like his counsel, or do I let him know that ahead of time and try and leverage that?
I don't think you necessarily have to. I think that it would go better as a conversation if it's just from you to him, parent to parent, about Luke. But what Katie and I can do is send that demand letter, and then his attorneys will have the duty to let him know that, hey, we received this. We have to address it.
Okay.
And all of this is a lot of information. We're
Yes.
aware of that. So please take some time, if you would like, just to think about what's best for your situation. Because if you don't think calling him again is going to make your situation any better, then you don't have to do it. If you think sending the letter on, like we said, from us would speed this process up, then we'll be glad to do it. We'll be glad to help you in any way that you think would be best. We just want to give you the different options that you do have. And so if you want some time to think about it, please feel free to do that as well. And you can always call us and let us know what you decide, and we can move on from there if that's something you're more comfortable with.
Okay.
All right, now going back to your goals, your first one was, I want an answer. Can Deborah do this? I hope we've given you that answer.
Yes.
To me, it seemed that your second goal was really Luke.
Yes.
And I know your children are your first and utmost priority, but when I'm thinking about Luke, when I'm thinking about what can help him, I think this conversation is the best for him, because what we're talking about is really just going to muddy the waters legally. Filing papers, who can represent you in court. It's not going to address his grades right now, his livelihood, his happiness. Mm-hmm. And your priority is his happiness. So I'm hoping this conversation goes well, and you can do what's best for your son, which is what you came in here to do.
And just following up with that, we do know counselors that work with kids, sometimes kids at this age, they're going through a lot.
Yes.
And so we'll be glad to give you that counselor's number. You don't have to use it. It's just something if you want to, we'll provide you with that information. If you think Luke would benefit for that, or Molly, I know you said she doesn't have any problems, but we'll be glad to give you that information if you would like.
I would definitely like that information.
We'll be glad to do that.
All right, so we've addressed that conversation. I have it on your action plan. The second thing is just that demand letter. Now, I know you mentioned fees, which is something that you wanted to know about. Mm-hmm. With that demand letter, Katie was going to speak to you more about fees, but we could do that. I know you said you want to wait. If you want to wait, obviously we won't do anything until you want us to. Is that the decision you have today?
I think so.
Okay, perfect. So I'm just going to put a question mark here, because once you have that conversation with him, you'll be able to let us know how you want us to proceed.
Okay.
And with that, just like the fees, like we said earlier, it is $200 an hour, but that's something that could be done within an hour. So that would just be the $200 for us to send it. We would get a limited scope representation for you to sign, and that's just to say that all we're doing is sending this letter. But should something come, if they don't respond, if you want us to file a grievance because they haven't stopped working as his attorney, that's something that we can get. We'll get a different engagement letter with you. That's what we call it. That's just a contract between me and us as your attorneys, and the fees will be discussed in that letter as well. But for the demand letter, it would just be the $200 for us to draft that letter for you to read, and then we could send it to them.
And with that, I guess my question is when we're doing that side of the situation, would that delay the child modification issues?
It could. And that's why I wanted you to have that conversation, because
Okay.
Luke's your priority. And if
Yes.
you want to answer to a resolution to the child modification, him not having counsel, his counsel having to withdraw, that's a much more formal process that will take time.
Okay.
But also with that, you just want to think, when you're thinking about everything, is you don't want anything to affect your child modification. So if you think for any reason Deborah knows some information that might affect you in a negative way, it may be a positive thing to make sure that she is no longer, or that Phil is no longer a part of his case. So that's just something, I know it's not always easy to hear the tough things, but that's something just to consider as well, that you don't want anything to negatively impact your child modification.
Okay. So what I'm going to do is just give you this action plan. I'm sure you can remember, but for me, it just helps to have things written down. So hopefully this assists you as well. Here is my card. What I will do, Shane, is walk you out that counselor's information Katie mentioned. We can get it for you. We have a sheet. That way you can have it, and if you just, use it if you need to, and if not.
And so just moving forward, just take a few days to think about it if you would like. Think about it tonight, call us back. Just let us know what you decide that you want to do. If you don't want to do anything, that's okay too. But we know time is of the essence for you, so if this is something that you want done now, just whenever you decide, give us a call back and we'll be glad to do that demand letter, or we'll be glad to file grievance, whichever way you would rather do.
Perfect. Now you came in here with some heavy stuff. Do you feel just a little bit better, a little more informed?
I think I feel a little bit more, less confused on this particular situation.
Perfect.
So I appreciate that.
Our goal today is for you walked in with that burden alone and put that on 2 more shoulders. So that way it's a little less heavy for you walking out.
Perfect. Thank you so much.
Yeah, thank you, and please let us know what we can do for you.
I will.
I'll walk you out and get you that information.
It's very nice to meet you.
It's nice to meet you.
Thank you.
Thank you.
What are you thinking?
I think her goal is her son, and I think the situation prolongs that. That's my concern. I do think Kate, if she calls back and says that he was not amenable and that she has to figure out what to do, this might be a situation where we go pro bono, because she's a single parent. She just said she works part-time, and I get it. I mean, I was raised by a single parent. I would be open to taking this case pro bono.
Yeah, and that's something we'll just confirm with our firm, but I'm in agreement with that. I'm just concerned with Deborah can't do that, Phil can't do that, and so we need to make sure that that doesn't affect her child modification if Deborah has learned information through that process that even she might not think would be adverse to her
Right.
through that process. So maybe she can speak with them. Maybe they can settle it without having to go the attorney route, but if not, we can help her out for sure.
Right. It doesn't seem that Deborah was screened at all in any way. In fact, she was involved with the case. So I certainly think there was a rule violated here, but the disciplinary process isn't going to get her what she wants.
Yeah. So I'll let her think about it. In 48 hours, if she hasn't called us, one of us can reach out to her just to see if she's made a decision, just because it is very time sensitive for her.
Right.
And then we can move on with whatever she decides.
Okay.
Sounds good.
So our secretary was telling us that I believe it's Shane Tanaka is going to be coming in to talk to us about potential issues with a mediator that helped this client in a previous divorce, and now it's a former mediator, but there's current issues. So let's see what's about to happen.
All right, let's figure it out.
Shane Tanaka? Hi, I'm Jonathan Speed. Nice to meet you.
Nice to meet you.
Want to go by Ms. Tanaka or Shane? Okay.
You can call me Shane.
Awesome.
Shane, I'm also John. Nice to meet you.
It's nice to meet you. Oh, 2 Johns.
Yeah, make it easy for you.
We're here.
Thanks for coming in.
Thank you for setting up the appointment.
Of course. How are you doing today, Shane?
I'm good.
All right. Well, we're glad to hear it, considering you had to come see us. But
Yes.
Yes, and before we get into everything, I just want to make sure outside of, I know our secretary was telling us outside of this context, you've met with attorneys for a divorce in the past and with a mediator. Is that right?
Correct.
Okay. And outside of that context, have you met with any other attorneys before?
No.
Okay. So just going to let you know here, I'm sure you've heard it before, but between us, this conversation we're having now, there's a confidentiality. So if you say something to us right now, it won't leave us or the firm that we work for.
Okay.
So, our paralegals and all our secretaries sign a confidentiality agreement so that we can review your information and help you out without you worrying about this information getting out. As far as that goes, though, we don't create the relationship of attorney and client until after we sign the retainer agreement. I just want to make sure you know that. So whether it's signed today or whether it's signed another time, that's when the relationship starts. But for now, just know that what you say in here is confidential between us. Does that make sense?
Yes.
Okay, gotcha.
All right, Shane, before we get into talking about why you came to see us today, I'd like to kind of run through what we're hoping to accomplish in the meeting today.
Okay.
First, we always like to get to know our clients a little bit more so that we can help you. We always find that it's easier to help others when we know a little bit more about them. So after we get to know you a little bit more, we'd love to just kind of sit back and shut up and listen to what you have to say, anything you think might be relevant that would help us help you. After that, we'll go ahead and make sure we have everything we need by asking you some questions to clarify. And then we're going to dive into talking about what the legal options might be and maybe even next steps. And then last, we'll wrap up with the most fun part, which is talking about our fee arrangement, and then I'll go through our engagement agreement with you as well. That all make sense?
Yes.
Okay, awesome. Well, with that being said, why don't you tell us a little bit about yourself?
So, as y'all know, my name is Shane. So, I'm 40 years old. I have 2 children, Luke and Molly,
Okay.
and I work part-time doing retail.
Okay. What kind of retail do you guys do?
I just work at Nordstrom.
Oh, okay, cool. Gotcha. So some good deals on clothes then.
How old are Luke and Molly?
So Luke is 14 and Molly is 10.
Okay, gotcha. They
All
playing
right.
sports at all or not there?
Luke's a freshman, so he's just trying to dip his toes in and kind of see. I hope he'll do sports, but we don't know.
Understood. Yeah, good ages, honestly.
Yeah.
It's
Yes.
getting into some fun times there. Well, we've been practicing in the area for about 10 years now. I've been married for about 3, and we graduated from law school just a little bit before we came out and set off doing this. We do kind of general practice, but we've had a lot of experience with professional responsibility cases, which is kind of the rules that govern how professionals, specifically lawyers, have to conduct themselves. And I'm sure that you know that partially because you're coming to see us today to talk about another professional in our field.
Yes, among other things.
Okay, all right.
Well, why don't you go ahead and tell us? I know, all we know so far is that our secretary told us that you're having a problem with a mediator from a past divorce case. So why don't you tell us what's going on?
Yes, so the mediator, I guess jumping to that part, was Deborah Noon, and she mediated Alex's and I's divorce about 4 years ago. And that went well. It was all pretty much amicable. We just discussed, really with her, was more of assets and financial support moving forward. And she really didn't have anything to do with the child custody.
Okay.
We did that amongst ourselves, Alex and I did.
All right.
Okay. And so you came to an agreement and that was signed by the end of the mediation?
Yes,
Okay.
and then the child custody agreement was signed between the 2 of us.
Okay, gotcha.
Now, you said it was Miss Noon,
Mm-hmm.
and she helped you with the mediation. That was just in regard to the distribution of assets, and you said she didn't really help you at all with the child custody
Correct.
issues. Okay, so and then the child custody issues happened after your interaction with Miss Noon?
Yes.
Okay, can you tell us a little bit more about that? How did that happen?
So I guess this is the most recent thing, and the thing that's been stressing me out the most was, so I think almost 3 weeks ago we had a hearing for child modification of our current custody agreement, and just due to some problems with Luke and Luke expressing some concern with me and that whole situation.
Okay.
Okay.
And how does Ms. Noon fit into this situation?
So Alex came in with counsel to the hearing, which I wasn't expecting. I didn't come in with counsel. And he was represented by Phil Tepper, who represented him in the mediation of our divorce 4 years ago. And what I found out after the fact is at the courthouse, I saw Phil, Miss Noon, and my ex Alex all talking together. And so that kind of concerned me, and I became a little confused. I later found out that Deborah joined the firm with Phil. And so Deborah is actually an attorney with Phil, and they both do family law. They're the only 2 that do family law at that
Okay.
particular firm.
And did Ms. Noon or did anyone represent to you that Ms. Noon was also representing Alex?
So I had some concerns and I was just really confused. So I contacted my ex-husband, Alex, and asked him what's going on basically. Is Deborah representing you? And he went to Deborah, and Deborah said that it could be possible that she would be representing Alex. And that because there were no, they didn't talk child custody during our mediation, that she could be the lawyer on the other, representing him in this particular case.
And the particular case would be the modification of the child custody agreement?
Yes.
And, and you said that, who initiated the child custody modification?
I did.
You did? Okay,
Yes.
Can you tell us a little bit about why you sought to do that?
Yes. So Luke, as you know, he's 14, and
Right.
so he a couple months ago came to me and said that he's been fighting a lot with my ex-husband, just about homework, that they just really haven't been getting along. It's been very hostile, and what I saw personally is that his grades are plummeting, and they're plummeting fast, and so that's just really concerning to me. Freshman year of high school, that's when grades start to matter.
Absolutely.
And so it's really concerning, and I really want to get it fixed. And so I attempted to talk to Alex. That did not go well. Of just maybe having, Luke has expressed to me that he wants to live with me.
Okay.
And so try to talk to Alex about that situation, maybe just making it more during school, that he would stay with me, and Alex was just not having it.
Okay.
And let's jump back to the mediation for a minute. As far as the mediation goes, when you were talking to Ms. Noon, did you share information with her regarding the children at all?
She knew general information about the children. I don't remember to the extent off the top of my head. It was 4 years ago.
Mm-hmm.
But if you had to categorize the information you were sharing with her generally, would it be financial, or how would you categorize it?
I think more just financial and support-wise, because I would be getting support as spousal support.
Mm-hmm.
She knew that I had kids, and she knew a little bit about us wanting to go 50-50.
Okay, gotcha.
Now, when you went to this representation, you first learned that your ex-husband, Alex, had representation. That was the first time you found out that this was going to be more of a confrontational thing and you didn't have representation, is that right?
Correct.
Okay.
I went in thinking that we would just both come in and get this settled through the court, since he didn't want to do it outside of that. I was really taken aback when he showed up with his attorney.
Okay.
So what I'm going to do now is just try and recreate your story that you were telling us, just so that I know we're on the right track. Tell me if I'm missing anything, interrupt me for real, and then if you want to add anything, let me know. Okay, so you said about 4 years ago you went through the mediation with Ms. Deborah Noon for the divorce, and that was related to the equitable distribution as far as allocation of resources. Is that right?
Yes.
Okay. In that you didn't talk about child support or child custody. Is that right?
We didn't talk about child custody.
Child custody. Okay. But you did mention that you had kids as far as determining the equitable distribution.
Yes.
Okay. And then after that, about 3 weeks ago, Luke came to you talking about Alex and about how he was having trouble with your ex-husband.
A few months ago.
A few months ago, okay. And then the modification hearing was about 3 weeks ago?
Yes.
Okay. And then after you called Alex, talked to him, he was not amicable. You got to the hearing and you see that Alex is represented by counsel Phil Tupper, is that right?
Yes.
And was Ms. Noon also there?
She was in the courthouse, but not particular at the hearing.
Okay, gotcha. So not in the hearing room at all then?
No.
Okay. And then after you contacted Alex regarding this, he said that Deborah told him she might also represent him?
Yes.
Okay. Did I miss anything? Is there anything that you want to add to that?
I mean, she just told him that there would be no issue with her going ahead and representing him, that she could very well be the attorney on
Okay.
on the other side.
Gotcha.
And just to make sure that we're all completely up to date as to where everything is right now, can you just tell us what stage of the modification of custody agreement process you are in right now?
So at the hearing 3 weeks ago, we basically just discussed sharing information about Luke's grades.
Okay.
And then scheduling for the next hearing, which is 2 weeks from today.
2 weeks from today. Okay.
Good to know.
All right. Well, what we're going to do now is we're going to kind of talk about some of the legal implications that we've been thinking of as you've been telling us all the facts. And while we're doing that, if you think of anything else that you think might be relevant, or if you have any questions about something we're saying, feel free to just cut us off, stop us, and kind of ask or let us know about something else.
And also, I see you have your own pad and pen there, but if you need extra, we have some for you. Feel free to take water. use the
Of course.
tissues. But like you said, interrupt us. If you don't want to interrupt us, write something down and definitely let us know, okay? All right.
Now, when we're discussing legal implications, it's also important for us to know exactly how this has affected you and what you would like the outcome to be. And that can kind of help us mold our recommendations and our research and thinking to what would be best for you. Because ultimately, especially if we end up continuing with our relationship, our job is to do everything in your best interest and to try to get as close to the best outcome and your ultimate goal as we possibly can. So with that being said, something we like to ask all of our clients is, if you had a magic wand and you could do anything with that wand other than replace what already happened, what would be the best outcome in your mind?
For Luke to be able to be living with me, so that way we can get his grades back up. I think that's...
Of course. And what about in regards to Miss Noon and Phil and Alex?
I mean, if I had to say something, just making sure that Deborah's not able to represent him, that just makes me really, really uncomfortable.
Okay.
And just being able to know if her and Phil can, if they've talked, if Phil is still able to represent him too.
Okay. All right. Well, thank you very much. That's going to help us a lot with understanding how we can possibly help you.
And before we get into, like John was just saying, the actual legal terms that we're going to be using, let us know if something's confusing, because there's quite a bit of stuff that we're going to talk about, and let us know if you have questions about it. So I believe what we would like to start talking about is the rules of ethics for attorneys. Attorneys are not supposed to represent, let's say if you were her former client, Ms. Nunes, she's not supposed to represent somebody against you in certain situations. We have certain rules for that. Specifically as it relates to her as a mediator, we have rules that say if she participated in a matter, so participating in a matter is a legal term of art, meaning substantially, I can't remember the exact language.
Personally and substantially.
Personally and substantially. If she participated in it personally and substantially, then she can't also represent somebody in that same matter. Does that make sense?
I guess, so does that include the fact that we didn't talk about child custody? Would she still be subject to that?
Well, see, that's a great point. That's the ultimate thing we have to kind of look into. A lot of times with legal standards, there isn't necessarily a yes or no answer or a 100% accurate thing we can tell you right off the bat. It requires a little bit of research and analysis. That is the issue you've identified of this case, is whether or not when she was mediating for you, she participated personally and substantially in a way that she could have got information that would raise a conflict when she's serving in this other capacity, perhaps helping Phil or even directly representing Alex. And that's really the question we'd have to determine. Now, with regard to divorce cases specifically, we know that no matter what kind of situation happens with a mediation, whether it's contained to just assets or contained to just child custody, in the end, a lot of things have to end up coming out. And that's going to be some of the other questions that we have for you today. And also probably what we're going to ask you to do for the next time we meet is kind of gather as much information as we can about that mediation.
Okay.
And I think you raised concerns as well about Phil and the rest of the firm, right?
Correct.
So that same rule kind of governs that as well. So there are exceptions to this. So, maybe Ms. Noon couldn't represent Alex directly, but there's an exception that if their firm, a part where Ms. Noon is a part of, is going to represent Alex, Ms. Noon would have to be timely screened from the situation. And in fact, there's an entire process that we can go through with you if we determine in the end that she did participate substantially and personally. Does that make sense?
Okay.
So there's a possibility that Phil could still represent Alex if we determine that.
Okay.
So one of the really important things that's going to probably end up being determinative when we kind of do this research for you is exactly what kind of information Ms. Noonan would have had when she did the mediation. And I know you said that was a while ago and you can't really think of it. And it would be great if, by the time next time we talk, maybe you could think it over and kind of have more information for us with that. But going off of what you do remember right now, you said that there was a lot of talk about your assets. Also, what about Alex and yourself personally, as far as your relationship and your marriage? Was there any conversation about that during the mediation?
Yes, there was.
Can you describe that to us? I mean, you don't have to go into detail, but as far as that goes, you did talk about children, and what else did you talk about?
We talked about the reasons for why we got divorced, and then like subsequent issues after deciding to go ahead and separate, and how that all played out.
Okay, gotcha.
And you see, that's all going to be some things that's important for us to determine whether or not Ms. Noon would be disqualified from helping in a case that's basically against you. And really, what these rules that we're governed by are trying to get at with this situation is, if an attorney has gotten any information that would give them some sort of an unfair advantage because they know confidential things about you, we don't want them to be able to use that to your disadvantage. Mm-hmm. And there's a possibility, especially because divorce is so intertwined with everything, because it's really your life. Yes. There's a really good possibility that everything that Ms. Noon learned about you could potentially lead to them having an unfair advantage, and that's what the rule is there to prevent. Mm-hmm. Now, like John was saying, there are some exceptions, and there are cases where a court or even a committee of the Bar Association can determine that the attorney that previously helped you, so Ms. Noon, didn't actually have that much involvement or didn't get that much information. But what that is what we'll call like a legal determination. And like I said, it can't be 100%, especially not today. But if you'd like to engage us going forward, that would be something that we'd be looking into, is kind of looking at the rules, looking how other cases have turned out similarly, and determining whether we think that in your case, Ms. Noon had that kind of information that would disqualify her. Does that make sense?
Yes. I guess my main question is, how does that play into the timeline of this child modification? I mean, that like getting this resolved in a timely manner is like of my utmost importance. I mean, my son's grades are what's important here.
Absolutely.
And getting him to be able to live with me. And so how does that whole situation with Deborah, like, when's the soonest that we can figure that out so I can get this other thing handled?
So as far as that goes, there's a couple options that we can take. Your goals specifically are, I think your main goal is to ensure that Luke is with you.
Correct.
Right? And secondary, you also don't want Deborah to be a part of that. You want this hearing to be as fair as possible for you.
Yes.
There's a couple options we can take. We could move, so we could make a motion for the removal of Deborah, if she is in fact part of this firm, from the case. We can do that for you. That would be a most likely immediate action. And in fact, what we could do, I'm guessing, we have to make sure that we find the correct rules of the jurisdiction, but file for a temporary restraining order as far as that goes, keeping her from the case. It's something like that. So those are some options that we can do for the immediate situation. And if in fact, after reviewing everything, we find that Ms. Noon actually has, participated substantially and personally in the matter, and now she's helping Alex with his case, or even if it's imputed or given to the firm that she's also giving that information away, we can do something what's called filing a grievance against her, which is that she has breached the rules of ethics. That will take a little bit longer. In our jurisdiction, the way that works is this. You would get with us and we'd fill out this form talking about, okay, what happened? And then after that, we would type up a narrative basically describing the entire situation, and then we would send that to the bar. That's the governing body of lawyers in this state. And then after that, they would review it, they would do an investigation, and they would do what's called a preliminary hearing, checking to see whether there's enough information to move forward. And then after that, they would send a letter of notice to the attorney, and then that attorney then would have 15 days, which in this case it would be Ms. Noon, to respond to it. So that is the longer term answer for that one. As far as Luke's situation goes and this very close upcoming thing, we have those, as well as if you want us to, we can help you with this specific modification itself.
So I guess when you do that, will that prolong the modification if we do decide to file a grievance?
The grievance filing itself won't impact the modification at all. As a matter of fact, if we do move forward with our relationship and we're helping you with not only dealing with the Miss Noon problem, but also generally with the modification of the custody agreement, then the first order of business, as John was saying, would be to file a motion to disqualify. And essentially what that would be is telling the court, hey, we know we started with Attorney Phil and Attorney Miss Noon. However, there's a conflict, and we believe they should be disqualified because of that. Now, the research on that, like I told you, we can't answer it today, but we have a strong feeling that, especially because of divorce cases that we've worked on before, so much information comes out in these kind of mediations that often judges construe it, what we call construing it broadly, which means they err on the side of caution. And they say, you know what, you probably learned information you should have. You can't work on this case. So what we would do is the first order of business would be research, make a determination, and if we determine that she should be disqualified and you engage us, file a motion to disqualify with the court, which would get Phil and Miss Noon off of your husband's case. Does that make sense?
Yeah, it's my ex-husband.
Sorry, I apologize. I apologize, your ex-husband, Alex, yes.
So, and I believe your concern as to which parts of this will lengthen the amount of time before this modification hearing, is that right?
Yes, because
Okay.
we worked well in mediation before. I saw that as a quicker way to kind of get through everything, and so I was hoping to mediate this again rather than have to go through the extensive court process. Do you see that as a possibility?
I certainly do, as far as that goes. As far as getting Ms. Noon removed, that is another situation to deal with as well. So I think we should talk about those separately. So as far as the actual getting her removed or disqualified is the exact term, that may put a wrench into things. So it may, the court has to evaluate. You have to go before the judge and say, hey, what's going on? Why is this going on? The judge has other cases too, so that could lengthen the amount of time.
Okay.
But as far as mediation goes, if you could, and if we would get with you and do this, send a letter to, their attorneys and say, we would like to see what the participation is currently, right? Who's participating in this? Who has done what? Does Ms. Noon, has she been sharing information? And if she has not, then we can do a mediation. And I think that would be a faster scenario for this. And I think that's probably one of your better options.
Okay.
Yeah.
So it sounds like your main concern is to obviously have a favorable outcome as far as Luke's custody and to get it done as soon as possible. Am I right? Okay. And I love that you suggested mediation. It really tells us that you're trying to get this accomplished with as little conflict as possible. And we always think that mediation is a great route to go. Now, if you were to engage us, what we would probably end up doing is determining whether we think that it's necessary to request that Ms. Noon and possibly even Phil get removed from Alex's representation and then suggest that we move forward with mediation. However, you are the boss here as far as we are your employees if you engage us. Okay. And so there's also always the option of if you don't think that any harm has been done right now, you could actually consent to the continued representation of Alex by Phil, and we can still push for mediation.
I don't want that.
Okay.
I just seeing them talking together outside the courthouse, that just really rubbed me the wrong way.
Understandable.
And I don't really, I would rather it be as fair as possible.
Of course.
And I just don't see that. And Phil having been his attorney in the divorce as 4 years ago, I don't see that as probable.
Understandable. I wanted to make sure that you knew all of your options, but I completely understand.
Yeah. And if mediation, just to be clear too, let's say that mediation is not an option, I think that would be a good option. We have to ensure that it works for custody, and I just want to make sure you know that. We can research that immediately and be able to tell you an answer within a day or so as far as that goes. If mediation is not an option, what would your next choice be if we have to lengthen the amount of time for this modification? Would you want to move forward with the disqualification proceedings?
Probably, yes.
Okay, gotcha. Well, in that vein, when we talk about options, we also like to talk about what we call the risk-reward analysis. We've been telling you about what the possibilities are, but shooting you straight for this, it's first we have time, we have cost to you, and then you obviously have, what's that going to do to Luke? What's that going to do to, your entire family? Those are things that you have to think about. The longer this goes, the longer process this takes, the more that's going to cost you money, the more it's going to cost you time. And I think you know that. And I think it'll be easier on Luke to deal with this faster. So if we can find a way, and I think, if maybe you won't like it, but if Phil stays on the case, it might be faster. That's only if Ms. Noon has not been part of this. Mm-hmm. That might be the faster option, is to do with that, since the hearing is in 2 weeks, you said?
Yes.
That might be the faster option as far as that goes.
Okay.
That may not be the one you like the most.
Okay.
But if Ms. Noon is not a part of this, and if she has been timely screened, like we talked about earlier, that's probably your fastest option.
Okay.
And if that's what's most important to you, that's something to consider. Mediation, it costs money for the mediator, you know that. It costs money for that, it takes time to set that up. The mediator has to look over all the records. That still will take time as well. So just want to make sure that you know everything.
Yes, and I guess what is y'all's, if I were to go ahead and ask y'all to represent me, what are y'all's fees?
Yeah, and I think that's basically what we talk about next is, so our fees right now are $200 an hour.
Okay.
And after that, we also ask for a $3,000 retainer. That's not a true retainer. So what that means is you'll give us an advanced payment of $3,000 that covers the amount of hours that we will be working. And what we'll do is you'll put that in a trust account. And we'll take money from that as we work, and we'll send you a bill letting you know what we're taking from that.
So
Does that
you
make
do
sense?
that regardless of whether we go to mediation or trial. That's basically non-negotiable.
Specifically what this is this is our hours that we're putting into this for research. And that's what we charge for those hours of research while we're
I
filing
meant
for
the
you.
$3,000 retainer.
Oh, yeah.
So that is just non-negotiable.
As far as that goes,
Well-
are you unable to pay the $3,000?
I mean, I'm just trying to find the most economic situation. That's why I want to do mediation. And so,
Of course.
just kind of like getting all of my options here too is just seeing what I have to put up front.
We always like to be able to work with clients, and so if you have some sort of financial hardship or you would like to adjust that, we most certainly can work with you as far as the amount that you put into the retainer. Essentially with the retainer, like John was saying, it's an advance payment. So say that we charge $200 an hour and we do 3 hours of work, right? And so that's $600 right there for the 3 hours of work, and that's going to be deducted from the $3,000. Now say after that for some reason, we don't have to do any more research. We're done. The remainder of the $3,000 will be immediately returned to you. It's not just to secure our services and you don't get it back. It's really just to have in there so we can withdraw from as we do work. So we can continue working even if you're unavailable to say, send us a check in the mail every time we do something. Does that make sense?
Okay.
And so certainly usually $3,000 is our standard to start with, and of course we return anything you don't use and ask for more if we have to continue. But if that's something that's not doable for you right now, you can certainly let us know and we can work with you.
Okay.
All right, so how's that sounding so far?
I think that made a little bit more sense. I was
Okay.
just questioning.
No
Okay,
worries.
perfect. And considering here, it's likely that we're going to have to also make some filings with the court concerning the motion and dealing with Phil and Miss Noon. What we also ask for is a flat fee of $500. That's the same exact idea as the $3,000, but the only thing that $500 will be used for is the court costs and the fees. So if we file a motion and it costs $25 to file that, that'll come out of that $500. We like in the firm to keep everything kind of separate on our accounts. So what we get paid for our work is from the $3,000, and any fees that the court charge us is from the $500. Does that make sense?
Okay.
Okay.
And John has our retainer agreement here for you. He's going to fill all that information in for you to look over. But while he's doing that, I want to explain to you how we keep in touch with you.
Okay.
We have this service, like a cloud-based service. It's called My Case. What that is, it allows you to access all the research we're doing, all the information that we're gathering yourself from your home. It's a secure cloud-based service, so what you can do is log in with your own login in your own username that only you know outside this firm. So, us, our paralegals, and our secretaries know the login because we need to work on your stuff. But you can log in from home and see it, right?
Okay.
So you'll see where we are, you'll see the research we've done, you'll see any sorts of comments that we've made regarding that research and regarding what's going on with you. And then what you can do is, it has a comment section next to it. You can leave comments there, you can ask questions there. If you're confused about something or if you don't like something, you can leave a question there or a comment. And we will not respond immediately necessarily, let's say it's midnight, but we'll try to respond in a reasonable amount of time.
So is that in place of actual, I guess, over the phone communication or speaking just because you're doing everything online? Does that mean I'm going to have less FaceTime with you as my counsel?
Not at all. And we always go with the form of communication that our client prefers. What we're trying to do with this system is we've noticed in the last couple of years, the biggest complaint about lawyers is that they just aren't able to be contacted and they don't respond quickly. What we're trying to do with this software is kind of open an extra line of communication that might even be more convenient than sending an email or trying to get in touch with us via phone. This is something that we can always have access to and see what you've commented or what you've messaged. It's just an easier way. But if you prefer to give us a call or something, you can certainly do that. Of course, realize that we're not going to always be in the office, but we always try to get back to our clients within 24 to 48 hours.
Okay.
And if you're uncomfortable with this cloud-based service, we understand. It's your information. We don't have to use it for you if you don't want to. Are you comfortable with us using it?
Yes, I was just concerned about communication.
Yeah, nothing wrong with that. Yeah, completely understandable.
So Shane, I'm just going to go ahead and give this to you. You do not have to sign it today, but we'd love for you to take it and look it over the weekend.
Okay.
And we'd also like to schedule a follow-up meeting with you. Now, one more thing I'd like to mention about this engagement agreement. I know that coming in here, you really didn't anticipate when you started the modification of the custody agreement, didn't anticipate having to get another attorney and do all this stuff because, like you said, you thought it was just going to go in and talk about it with Alex and the judge, right?
Yes.
So because of that, and because it seems like you're going to be having more legal fees than you really anticipated, I know that our secretary, Caleb, told you today was just a flat $100 fee.
Mm-hmm.
I've taken the liberty of going ahead and waive that for today, considering that we feel bad that you couldn't have possibly anticipated all of this happening. All right? I just wanted to let you know that.
Thank you for that.
Of course.
And as far as we go with the next steps, I think what John and I have been talking about is we're going to do some research and get back to you as soon as we can because we know that this deadline is pressing for you,
Yes.
2 weeks. And in doing so, we also have some homework for you.
Okay.
What this is just basically information that we'll need. So you'll get the access information from Caleb on the way out
Okay.
to my case. And what we need from you is any mediation documents you have from before. And then divorce documents, custody documents, if you can send those to us as well.
Okay.
And then any written communications you've had with Ms. Noon.
Okay.
Those will be helpful for us. We may ask you for things in the future, but what we want to do is get that information as soon as possible to help us help you.
Okay.
Does that make sense?
Yes.
Okay, good.
Okay. Well, with that being said, before we say goodbye, do you have any more questions for us?
Not at the moment.
Okay. Well, Shane, we'd love to be able to just do a little research. We're going to look into, first of all, the child custody laws that we're going to have to be facing, in addition to the local rules as far as filing a motion to disqualify Phil and Miss Noon, and in also concerning mediation of child custody. We're going to start on all that for you over the weekend here. Do you have any availability on Tuesday for us to meet again and kind of go over what we've done and discuss our next step further?
I'll have to check my schedule and
Okay.
picking up with the kids and things like
Of
that.
course.
Do you mind if we give you a call on Monday or so and see where you're at?
That would be great.
Okay.
Sounds good.
We will
Thank
make
you.
sure Caleb knows because we want to get this done for you as soon as possible. We understand it's pressing and it really is something that needs to be taken care of right away.
Yeah.
Perfect.
Do you have any other questions for us?
I do not.
All right. Well, thank you for coming in.
Thank y'all so much.
Yes. John will walk you out here. But have a great rest of your day, okay?
Thank
Nice
you.
meeting you, Shane.
Shane, thank you so much for coming in. Have a great day. Thank you. All right.
Well, I don't think I can say right from the get-go whether or not Ms. Noon is on the case, but if she is, I think that's definitely a violation because she would need to get
Yeah.
informed consent confirmed in writing.
Right.
And obviously she hasn't done that.
Right. She didn't
Um,
even know there was going to be lawyers until she got to the hearing.
Yeah. And then as far as the imputation to the firm, because she wasn't necessarily in the hearing room, it's just what she heard from Alex, right? Since she wasn't necessarily in the hearing room, I don't know whether or not it's imputed to the firm if she's not actually on the case herself. So that's something we need to address right away, I think.
Right.
Especially with this 2-week deadline we have. And I think what we should do is move forward with the representation for her regarding this. That's her most important thing, is
Right.
getting Luke, right?
Right.
So move forward with her regarding the research for these things.
Yes. It seems like regardless of whether we determine that filing a motion to disqualify is the best course of action, she wants her top priority is this custody.
Yeah.
Right. And so I think what we need to do is get Rena in on this. Rena Lindevolt's our third partner because she's done a lot of family law stuff. So I think it'd be helpful to get some pointers from her as far as what our next step should be, because if it turns out that after we do some research, we find out that this kind of conflict is not imputed, we still need to be prepared to move forward with this modification of custody.
And I think it's important to determine whether as well the mediation will work for a child custody hearing.
Yes, I don't know what the local rules are. I know that sometimes
I-
some things can't be mediated.
That's correct, yeah. So just want to make sure on that, and that's I've tried to voice that to her as well, just
Yeah.
in case we can't.
Yeah.
What else would you like to do?
It's good that she
Um,
at least was willing to do something like mediation, though. It tells us that she's really wanting to move forward and be amiable at least with
Yeah.
this kind of stuff.
Yeah, I think that's a good idea. It's a good way to move forward from here.
Yeah, I am, It's a little bit complicated. I want to review all of the notes that we have and kind of do some research. I know that I was actually recently at a CLE, and they were talking about divorces specifically in regards to these kind of conflicts. And what they said, as I was trying to explain to her, was with divorces specifically, any of the mediation is kind of, everything is talked about, right? When you talk about the kids, you talk about the money, the houses, everything. If this was something completely unrelated, like somehow Alex hit her with a car and there was an accident like that, maybe that would be so separated. There would still be a question of assets, I'm sure.
Yeah, that's another thing is.
But it would be a little bit farther away. I mean, this is regarding the actual divorce, still the custody.
Yeah.
And so basically what the speakers of the CLE were saying was that courts have been construing this rule broadly about mediators, that especially in regard to divorces, a lot of stuff is considered disqualifying information.
Yeah, I think we could definitely, I mean, not definitely, but I think we're on the safer side with what you've been talking about as far as participating in the same manner. The question is just whether or not it's been imputed to the firm then, I guess.
Right, and it is interesting that Phil represented Alex in the divorce case prior as well, she mentioned. So he already has information as well. But now there's also information that, so they both have information about the divorce, and Ms. Noon possibly has even private information if they took during the mediation, separate caucuses to talk personally, then she might have even more information that Phil does not have.
So the only reason that she believes that, other than seeing Ms. Noon at the courthouse, that she's involved is that Alex told her that Ms. Noon is involved.
Right.
That's what I gathered as well. So what we should do definitely is check the status of this case.
Of course.
See who's involved with it. If she is not involved in an official capacity, that's a good sign at least.
Yeah.
But then obviously you have the question of, okay, has this person been timely screened at the firm?
And it sounds like if there's any possibility she's going to work on the case, she has not been.
Right.
And along that vein, it'd also be helpful for us to find out exactly how long Ms. Noon has been working at the firm.
Right.
Because I'm sure that Shane has no reason to know that kind of information, but if somehow we could figure out how long she's been there, that would also kind of be informative as to imputed conflicts.
Yeah.
Okay, so we have a couple issues going on. I would like to continue doing the research on this conflict of interest and the disqualification as far as mediators are concerned. I have a little bit under my belt already, so I'd like to continue with that.
And I'll sort of do the work with the mediation as far as the custody hearing goes, and I'll just check the actual court filings, see who's where, and I'll try and get in contact with Phil's firm. So.
Yeah, okay, so it sounds like what we need to move on first is determining whether we need to immediately file a motion to disqualify before the next court appearance, right?
Yeah.
Okay, so we should have that information ready for her. I'm going to try to get all that stuff figured out by Monday.
Sounds good.
Okay, so let's go ahead and do that.
All right.
So maybe before we get started with the feedback, if you guys could just introduce yourselves so that we know who you are and they know who you are, and so we can officially thank you for your service this afternoon. So if you want to start?
I'm Mark James. I'm an attorney here in Waco. I actually work for the federal government. But everybody did a wonderful job. Thanks for all your hard work.
Thank you.
My name is Cindy Culp. I work for a law firm here in town as well. I do personal injury, mainly on the defense side. I also was very impressed. Y'all do a lot better than some of the associates we brought in.
I'm Justice Lindsay. I work at another different law firm here in town called Name and How. I do civil lit and just a little bit of family lit. So.
So great. If you want to just start and over where y'all have decided and give our competitors some feedback.
We thought we would just go in the order that they came in and start that way.
Yeah, go ahead.
You want me to start? Okay, starting with Team E that came in first. I thought that you did a good job of, let me see, get my notes here. I got pluses and minuses. I thought you did a good job that asking why you didn't go back to the same attorney. I think that that's important. Sometimes with clients, they put on a show for you, but they're kind of sometimes cuckoo for Cocoa Puffs. And the fact that you asked, like, why didn't you go back to your old attorney whenever dealing this, that's something that I thought was a good thing, because if it's somebody you know, and it's somebody that you, like, hey, I've worked alongside this attorney for 15 years in the bar, and I don't, they're complaining about him or something like that, oh, he's a terrible attorney, then that could maybe trigger something like, hey, this client could come make up something down the road about me, and you know what I'm saying, and is this a client that I really want to take on? And so I thought that y'all did a good job of picking up on that. That was key. Let's see, something, I don't think that, and we obviously had a law student as our thing, so she was trying to, and she did a good job of doing it all equally. I think she was kind of hinting you at saying the words motion to disqualify. And you guys never, I didn't catch it, at least that y'all ever said the words. It's the procedural mechanism that you would use to disqualify Phil. And then I think that just wish I could have gotten a little bit more on the substantive, a little bit as far as like the rules and, you know, the whole Chinese wall and stuff like that, and how that's imputed on the whole, you know, the fact that, I can't remember the mediator's name, but the fact that she's now associated with the rule, like that firm, the fact that that's imputed on the whole firm, and I wish I would have gotten a little bit more of that. But I thought that y'all did a good job overall, and let's see, I did picked out 2 positives and 2 negatives for each team, or 2 improvements, not negatives. And I think that you did do a good job of asking her, straight up asked her what her priorities were, and you got those down. And that's the whole thing, right? Clients want to know, hey, like, what are your accomplishments? Like, what do you want to accomplish? Because sometimes they may not be what you would typically think of. So I thought y'all did a good job overall.
Thank you.
Well, right from the get-go, I thought y'all projected some care, concern, and confidence. I thought you had a very good, demeanor and just overall, just interacting with the clients. I thought you did a very good job. And kind of with that, I thought you did a good job of extracting a lot of the details, but without really seeming like you were prying. It was just sort of the way that you followed up on questions. That being said, I think there were a few times that there were sort of cues, like you said, that you kind of missed and could have done some more follow-up on, but I liked the way that you approached trying to draw that information out of the client. I thought you did a good job of trying to explore what some of the non-legal issues were, and that's important, obviously, when you're talking about a child custody case. Some of the things that could have been improved, you talked about fees sort of first off, and I'm not saying that there's a wrong way or a right way as far as order, but I could see where that would be off-putting to a client. And then at the end, she kind of had to come back around and circle back and ask about like the retainer. And there was no overall discussion of like, here's our best estimate for how many hours and therefore what's this going to cost. So I think that might be something you could think about doing in the future. A couple of times I thought maybe y'all were trying to just check the boxes on the things that you're supposed to do in this competition. Like there was one time when you said, well, tell me how that made you feel. And it just seemed sort of like a weird place for it. Oh, okay. So just, I don't know, maybe try to weave that in a little more naturally if possible. And then the last thing, when you were talking about your first immediate step was going to be to write a memo. I don't think if I was a client, that's what I want to hear. Maybe the way to phrase it would be, I'm going to do some more research or figure out the substantive law or whatever. But just the idea of I'm a client and the first thing you're telling me you're going to do is write a memo, I'm not sure I'd be real excited about that.
Well, this is a hard act to follow. I thought you both did a good job as a team. You balanced the questions. I think you both did a good job of establishing a relationship with the client. I like that. I thought, and this comes from a mediation background, which to me is a lot of what you're doing is working on communication. I thought you did a good job of reflexive listening, where you made it clear, it seemed to me like you were able to make clear that you were picking up on the things that she was saying. So, and I will say that when I was in private practice, the most disagreeable and the hardest part of any conversation I ever had with a client was about setting fees. So I yield to my compadres here that are in private practice. That's a difficult conversation to have, and I thought that there's no easy way to do that. So. Good job.
All right, moving to the Team B, which is the second team that we saw today. Again, thought y'all did a great job. Let's see, let me look at your name so I can address you over the right name. Tatiana had like 2 good things that I wrote down. You put the pen down. I really like that. Like you put the pen down and say, hey, let me address you as a person and just, you did a good job counseling around that. I thought that was really good. And I can't remember which one of y'all said it, but you did a good job of explaining, hey, there's like 2 buckets here as far as the with the ethical issues. We have the disqualification. I don't think that I ever heard you say the actual like motion to disqualify, which would have been, like the procedural mechanism, like I said with the first team, that would have been used to like actually get Phil out of the case. You kind of dance all around it, and maybe you didn't say it just because you didn't want to sound like legalese or something like that. I mean, I totally get that if that's why you didn't do that. But you did a good job of explaining the 2 buckets, like, hey, there's a disqualification of the attorney from the modification case, and then there's also the filing a grievance with the state, and you did a good job of explaining those 2 buckets, I think. And then also, I like you did a good job of explaining the substantive law, and then explained that you really did a good job of explaining that the burden was on them, like on the disqualified attorney, because it was imputed on them. And then you did a good job of explaining the Chinese wall, or that's how we learned it as Chinese wall. And so like that, you did a good job of explaining that. So I thought that y'all did a good job.
I'd say that both of y'all had a very natural and easygoing style with the client, and I thought that that was very effective. Tatiana, especially you, I think from the get-go identified, this is a mom coming in about her kid, and so therefore it's a very sensitive and heartfelt issue with her, and I think you did a good job of communicating that you understood that to her. And I think that kind of hand in hand with that, y'all did a good job of identifying different options, including sort of some non-legal options, such as, well, what about, would it be worth reaching out to your ex-husband one more time and just trying to see if you can reopen a dialogue? And so I thought that y'all did a good job on that. Some of the things that could be improved, although I like the idea of offering a cost-effective solution such as the phone call and the demand letter, I kind of got confused about why you talked about doing 2 separate engagement letters. Like, why limit the scope so dramatically to just the demand letter or the phone call at first? Why not, just talk about that as what that would cost, but that if it doesn't, work and more work is needed, you'll continue to represent her. So I kind of was confused about why you would limit the scope so much there. And I think there could have been a little bit more discussion about the family law representation. I know that you talked about you would refer her to a different attorney and everything for that, but maybe just focus on a few things more substantively to the family law issue. That's really, that's pretty much what I have to say.
Thank you.
All right, there you are. I've been very impressed. Trying to read my notes here. That's one of my problems.
Try going first, and then you don't even have time to look over your notes. You're just on the spot.
Yeah. I agree the 2 buckets thing was a thing. I liked, Katie, when you started out and you kind of leaned in and said, how are you doing? You heard the concerns about everything else, and then you said, but how are you doing? So that was a good point. Again, good reflexive listening. You could tell that y'all were listening, that you were letting her know by what your questions were, that you were paying attention to her concerns. I liked the option. One option you gave was pick up the phone and call. You could pick up the phone and call. That would be something. Again, if you're in the business of handling professional responsibility cases, and I'm not sure that how that was put out in the thing, so you have to talk about the grievance process, and it's like talking about fees. It's difficult to talk about the first thing. One of the things you may have to do is file a grievance against the attorney. I think that the first thing you would do in a situation is, and again, this is something in a smaller jurisdiction like here, is if you've got some, everybody on the bar pretty much knows everybody else probably kind of situation. You're going to pick up the phone and call, and I think that's always not only for client relations, but for future work with the folks you're going to have to work with for the next 40 or 50 years. It's probably a pretty good way to think about handling something like that. but again, a good strong showing by you guys.
Thank you.
So I'm once again impressed.
Moving to the 13, Team H. I think you guys did a great job of developing the facts. And then kind of similar to her phrase of the 2 buckets, I can't remember which one of you Johns said this, but the magic wand, you said, like, if you could have a magic wand, I like that, just because the same thing as the 2 buckets, it's a visual representation to the client that allows them to see, like, okay, if I did have a magic wand, they probably never thought of that before. Like, okay, if I had a magic wand and I could get whatever I wanted, how would I resolve this? And I mean, I think that's just a great visual representation, similar to the 2 buckets thing. And I think that plays really well, especially in competitions and stuff like that, when you're looking for things to really grasp onto as a judge. Let's see. Some of the things that I wish I would have seen better is similar, kind of like we were just talking about in the second team. I wish we would have heard the pick up the phone and call them. Especially, we practice in Waco, so I mean it's kind of beat into our heads. You don't do anything. It's a small legal community, and even in Houston, Dallas, you hear from those guys too. Like I clerked for a large firm in Dallas, and those guys did the same thing. Like, hey, it's a small legal community, and figuring out okay, before we just haul off and file a grievance or a motion to disqualify, which you guys did say, hey, that was a great thing that y'all did. Like, hey, this is the procedural mechanism for how we would get Phil out of the case, motion to disqualify. I thought that was good, but just suggesting, just trying to get to the bottom of that and maybe picking up the phone and giving them the opportunity to withdraw themselves before it. I think you have a duty to let them know that, hey, if that doesn't work out, the grievance process is there. But a lot of times when you say grievance to process to client, they immediately the clients they feel like they've wronged and they want punishment, right? And so if you say that, like, hey, there's a grievance process available, they're like, well, I want to go down that route, and then getting them off of that, it can be kind of hard. And obviously that's their choice if they want to do that. But at the same time, you want to make that clear that that's probably not the first initial step. And so maybe the phone call thing was the one thing that I wish I would have heard a little bit better. I thought that, and that was kind of under the alternative options. One alternative option that you kind of did get to eventually, that we were kind of having a little discussion about this, and maybe they'll address it as one of their negatives, but I kind of thought of it as a positive, is the fact that you re-suggested after she made it clear. She said, no, I don't want Phil continuing to represent him. I think that I can't remember, I think it was you, John, did the thing of like, well, hey, if what you've told us multiple times is your number one goal is speed on this, is getting this hopefully resolved in a speedy manner, the best way to do that is for him to stay on as his attorney, and we just mediate this. We represent you, and the other attorney represent them. We just get her to we get them to agree that she's gonna be Chinese walled off, and we mediate it. And I know that some of them, like, we had discussion about this, about whether, she made it clear she didn't want to do that, and then y'all came back and you hit it again. I think I took it as a positive, because I think that that's our job as attorneys, is to say, hey, I know that you may be initially turned off to this idea, but it's something that I like, in order to achieve the goals that you want to achieve, I think that this is the best route. And then I wish you would have followed it up with, now obviously it's your choice, and explained it up a little bit better, but I think that y'all we're thinking that maybe you just, you didn't, obviously you said that at the beginning, but it's good to follow up with, making a suggestion that, I know you may not be into this, but it's obviously your choice at the end. So I thought that was a positive that you guys did.
Well, I guess just to follow up on that note, as part of that discussion, I mean, I agree with everything that he just said. The reason I would have put it a little more as a negative rather than a positive is just because there wasn't that explanation. I think if you had just immediately said, okay, now, I really did hear what you just said about you're uncomfortable with Phil staying in this case, but let's talk about it, and here's why. Because if expediency is your number one goal, this may be the best way to go about it. And then, she, in real life, of course, she's going to clue you in on how she feels about that. So just a little more massaging there, just as something to think about in the future. But it is good as an out-of-the-box sort of a thing. I thought y'all did the really good job of communicating to the client that the fact that this is a divorce case makes a whole conflict of interest issue particularly pressing, and phrasing it as an unfair advantage. Did this attorney or would the law firm have an unfair advantage? And I thought that was a very good way to explain it to a layperson. So I thought y'all did a very good job there. I also liked the magic wand question, and it really extracted an answer from a client, and I think it would do so most of the time in real life, or at least give you a really good intro to extracting what their real concern is. So I like that. As far as kind of the wrap-up of the client meeting, I think you need to be more clear that y'all wouldn't start the research until you were officially retained, because of course you wouldn't. And the whole idea of a follow-up appointment, I could see pros and cons about it. To me, it came off as maybe a little pushy, rather than just offering to follow up with her or making it clear how she could follow up with you. The same thing about the cloud communication. That would be fine, again, if you had presented it as like an option. But I think probably what happened with her would happen in real life, like, okay, so you're wanting to communicate with me just through a web portal, so I'm not going to actually get to talk to you as a person. I think that's probably the reaction that a lot of clients would have. So again, I think that could be used effectively, just as, we're going to be as responsive to you as we can, but as you might imagine, I'm often in court or with other client meetings, so here's a good fast way that you can communicate with me outside of those two options. I think that might have been a better way to do it. The other, just a tiny thing for improvement at the beginning, I know it's hard to do fake small talk. Real small talk's bad enough, so fake small talk is super hard to do. But I felt like it was just sort of like, hi, how are you? And then it jumped right into, let's talk about confidentiality. I think you could have maybe worked on a natural transition there a little more.
Thank you.
Well, John and John. I also wrote down the magic wand thing. That was a good visualization. I think that was an effective tack. And I have to say that as I'm a government ethics official, believe it or not. I mean, that's what I do for the VA. And so you start, and I picked up, of course, you're talking about personal and substantial participation, and I'm thinking, yeah, that's right. And then the next thing I remembered is, every time I say personal and substantial participation in a particular matter to a doctor or a director, they go, what the hell does that mean? So it's good that you recognize the concept, but I can tell you that's a hard thing for people to understand. And so if there's some way that you can make it more human instead of, because that literally is, I don't even have to look at the keyboard when I'm typing something up. I mean, that's the magic words to me. And sometimes when a lawyer has phrases like that they're comfortable with, it's very easy for them to roll off the tongue. And a client doesn't always understand the level of particularity that's involved, So, but I like that you use that language. That is one thing that was a little bit of a turnoff for me was when the client said that she worked for Nordstrom's, and one of you guys said, "Oh, we can get a good deal on clothes." That was a little bit off-putting to me. And the other one, and was not the same one of you, said, let's talk about the good, and I know it was a joke, let's talk about the fun stuff, let's talk about fees. That's fun for us. May not be fun for a client. And so just, humor is something that I use that constantly with the folks that I work with, is humor, but you really have to be careful about how you use humor in a situation where you're not familiar with people. Because when somebody's coming in and they're paying money that's hard for them to come by, and they're coming in to see somebody, they don't want to, and it's not belittling, it's not putting them down, but they want to understand that you're taking the fact that this is important to them seriously. and don't, that may not necessarily be the time for that kind of humor. There's always, you could lighten things up, but you have to be judicious with that. So, but again, another really strong, this is 3 really good teams. I can see why this is the finals.
Yeah.
You made our decision very
Yes.
difficult.
So have you finished with your feedback?
I think so.
Finish with the feedback.
Okay, well, thank you for this competition.
Well,
I'm going to go ahead and make the announcement because I know you're like, we don't want to hear you yammer, we want you to just give it to us. So that the 3rd place team is Georgetown University Law Center. Team members. And your school.
Thank you.
The 2nd place team is Liberty University. Team members Jonathan Shabin and John Beard. Which I guess the 1st place team is Campbell University, Norman Adrian.